Your Lordship. Lordship, I would like to mention item number 36, Lordship.
36.
Lordship.
Yes, what about it?
Lordship, this is matter relating to non-payment of contractor. I would like to withdraw for non-joinder of necessary party.
Okay.
Jal Shakti.
Mrs. K.K. Chowdhury, learned counsel for the petitioner, prays that she may be allowed to withdraw the writ petition with liberty to file a second. The prayer is allowed. Writ petition is dismissed as withdrawn, with liberty as paid.
Public.
Item number 27 and 51, madam.
Yes,
I pay for adjournment for 2 weeks, madam.
27 and 31.
I've taken the consent.
Okay. Mr. B. Gogoi, learned counsel, huh?
Health department.
Learned counsel for the health department, prays for adjournment and submits that he has taken the consent of the prays for adjournment. Mr.
R. Sinha.
Mr. R. Sinha does not have any objection to the same. Accordingly, leave this matter after
2 weeks.
2 weeks.
Public.
31, no?
31, 27 and 50.
27 and 31.
May it please your Lordship. Lordship, item number 42, I have taken the consent of the other side.
Yes.
May we adjourn for a week, Lordship. It's a review filed by the state.
Okay, all right. You're for the state.
Lordship,
What is your name?
M. Devi, Lordship.
Miss N. Devi, learned counsel for the petitioner, review petitioner, prays for adjournment and submits. He has taken the consent of the other side. Accordingly, matter is adjourned for
Can you be on 7th of March?
7.
Wait, please, your Lordship. I'm praying for listing of a matter, your Lordship. Any date next week. Your Lordship.
New case.
2023 case, your Lordship. Arbitration petition, your Lordship. Last is on 5 to your Lordship. Order of this honorable court.
You
was
go and
released
ask the registry, Mr. Counsel. You ask the registry. Yes.
May it please your Lordship, as regards item number 52, Lordship,
Yeah.
claim for upgradation of the matter, Lordship. On the last occasion, Lordship, when the matter was heard on 9th by your Lordship, Lordship had granted us a liberty to make a mention for upgradation. That is likely to take up some time. Can it be taken up at 2, Lordship?
Okay.
I'm up 52. I'm obliged.
You're for whom?
I'm for the petitioner.
Applicant.
Lordship. Applicant.
Your application, you're asking for impleadment, you're asking for vacation, you should do it one at a time. You cannot have everything at one go. Yes.
May I please? Lord, I have helped to read petitioner, my lord, urgent matter, my lord. On
Huh?
5 to new case, my lord.
Yes.
For listing on Monday, my lord.
Lordship, prayer for listing WPC 6269/23, Lordship. Matter relates to settlement of market. Only 4.5 months left, Lordship. So, matter may kindly listed on 19th, Lordship, on Monday.
Difficult, madam. 2 minutes. Pleadings are complete? No.
Lordship,
Pleadings are complete?
from
Okay, make it Friday.
Friday.
Next Friday.
Yeah.
Next Friday.
Obliged.
Yes, I beg to mention read petition. Kindly list the matter on Lordship 21.
Is it a new case?
No, Lordship.
No, you go to the registry, madam.
Lordship.
Go to the registry. Next.
May I please, your Lordship? Lordship, I beg to mention for listing of a admission matter, my lord, petition, my lord. Next week, any date, my lord.
Go to the registry.
My lord, it's supposed to be listed after 2 weeks, my lord. Now it's 4 weeks, my lord.
What is the matter about?
The matter regarding, my lord, there is an investigation, my lord, which was delayed and therefore we have filed it.
Investigation regarding what?
Regarding, my lord, some FIR we have lost by the read petitioners, my lord. Thereafter, my lord, they against the, my lord, some fraudulent, my lord, work order has been issued by the accused as well in connivance with the government servants, my lord. The crores and
So
crores.
what is suspension? What is the matter?
No, my lord. It's regarding, my lord, fraud work order has been issued to us, my lord. We are the company, my lord.
So? Is that before this court? Is that a matter here? There's no hurry anyway. You ask the registry, go to the registry.
Okay.
May I, on urgent matter, my lord, may I permitted to, my lord, move tomorrow, my lord.
What is the matter?
Regarding settlement of cart by the, my lord, Panchayat, who has no jurisdiction.
New case?
New case. Obliged.
tomorrow?
Item number 45, motion matter supplementary list, my lord. I have filed an additional affidavit on 13th, my lord. That may be allowed to be brought.
Item one for motion. Yeah, Your Lordship. Lordship, this contempt petition has been filed against the non-compliance of the order dated 27.
Okay, right, Mr.
Ahmedabad.
M. Das, learned counsel for the petitioner, submits that the order dated 27/1/23 passed in WPC 3683. 2018 has not been complied with. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondents by registered post AD. List the matter after 4 weeks.
Item two. Lordship, in this, the order dated 27/1/23.
Out here, everything is same except writ petition number is 3674, 2018.
Obliged, Lordship.
No one appears for the petition on call. List the matter. Yes, who is there? No one appears for the petition on call, huh? Then Mr. Yes, what to do?
Other than motion issue notice, my lord, non-payment of contextual duty.
Right. And
It's of 2018 and 19, my lord.
so why don't you submit your thing?
Lordship,
Why don't you take instructions and file the affidavit?
Lordship.
This, Mr. No, the matter pertains to non-payment of contractual bills amounting to rupees 61,35,180. Issue notice returnable in 4 weeks.
Right.
Mr. B. Gogoi accepts notice on behalf of the respondent.
4, 5, 6, and 7.
Huh? 4, 5?
6 and 7.
4, 5, 6, and 7. Mr. G. Bokalai accept notice on respondents number 1, 2, 3. List the matter after 4 weeks to enable them to file their affidavit as to whether the amount is an admitted amount.
Item four.
Well, it's a matter, my lord, regarding electricity.
Huh?
Electricity, my lord.
Yeah.
Yes. Yeah, you also find, my lord, that a regulation has been issued at page 23, my lord.
Yes,
Fuel and power purchase price adjustment formula regulation,
yes,
as per section 624. And, my lord, in this matter, if your losses come to at page 27, 5.3. Yeah. My lord. Here, my lord, the formula applied for each quarter by distribution licensee without making it necessary to go through regular posting. The distribution licensee shall, however, obliged to provide all relevant information to the commission is simultaneously in any case where the commission observes that distribution same will be adjusted the next quarter. The mechanism shall ensure. FPA charge is usually incurred by the generic company which is passed on to the distribution utility who will in turn recover it from the consumers. Therefore, the generic company owned by the state shall also provide given details so and so. Then, my lord, now 5.4 proviso, second proviso. Provided the distribution licensee shall put up on the website such details of additional burden on account of charges in fuel price and power purchase cost, and the FPA charges shall be levied on consumers for each quarter along with detailed computation. Each control period shall be a quarter, year, 3 months. Quarter, 3 months. Accordingly, distribution license shall compute and adjust the amount of fuel and power purchase price surcharge. Thus, FPA in quarter shall be charged from the first of the month to the next one. So they have to, my lord, give into a my lord, website, this should be price, and from the next quarter, it will be implemented. This is the my lord system, and this has been clarified by the second, now another issue by the. Now here in this case, what happened, my lord, if you want to see, this is the page 31, which we are. This is under my lord. Page 31, you'll also see this notification has been issued, notice has been issued on 27th of May, 2023.
yes,
It is information of all category consumer that in terms of ARC regulation, fuel purchase price adjustment at the following rates levied to the respective category of consumer from the next 3 months with effect from June until further order. My lord, they say, this is my lord. Now, any adjustment regarding short excess variation within the stipulated will be adjusted. There is so and so. The adjustment will remain in force so and so. Well, now, here they wanted to implement it from June. On 27th May, this notification is issued. Energy consumed during May 23. How this can be done, my lord? It is retrospective effect they are giving. My lord, quarter, my lord, it starts from July. April, May, June, my lord. Next quarter, they should give it effect from July onwards, my lord. And now here they are charging it 27th May, they are issuing this notification. They are from 1st of May, my lord. This
So according to you, this should take place only after 3 months
July,
from the
July
date
onwards,
of
quarter.
from quarter.
That is the regulation, my lord. And that has been clarified by subsequent also. Similarly, another notice is issued similar manner, my lord. That is under challenge, my lord. They have already recovered it. I am not paid for any stay of anything, my lord. Let them file the affidavit, my lord. Yes.
This matter is very technical, Malus. There is an alternate remedy.
That's what I was thinking.
Yes, ma'am. There is a remedy before the ombudsman, Malus. My lord,
Okay.
I kindly have section 42 of the Electricity Act.
This is important. Give me that.
With regard to calculation of tariff and whether or not that tariff order is in order, my lord, that would require a technical approach, my lord.
Well, this is not a calculation. This is retrospectivity. Well, that is why I have come before your lordship, my lord. They cannot give it retrospective. That regulation actually provides for it. Now this another regulation they are going to issue, my lord. That I'm just showing you, my lord, how 6. If your losses turn to page 42, my lord, of the petition.
Subsection 6 of section 42, my lords. There is an ombudsman, my lord. There is a grievance redressal mechanism, my lords. Hey, he should probably approach the ombudsman, my lord.
Then this is a statutory alternative
No,
remedy.
the ombudsman cannot, my lord, this retrospectivity cannot be done through calculation only.
Huh?
They can go through calculation only, my lord. Not other than that. This point, the ombudsman cannot decide, my lord.
Any consumer is aggrieved by non-dismissal of his grievance under subsection 5
Yes.
may make a representation for to the
Then there is a remedy
every
for-
distribution licensee shall within 6 months from the point date or grant of license
Yes.
establish a forum for the
Forum, my lord. Ombudsman is not a forum, my lord, for this,
It is a
for this purpose.
No, why is it not a forum? It is a forum.
My lord, retrospectivity that cannot be decided by the ombudsman, my lord. That is what I am submitting, my lord.
if the issue is with regard to his grievances, then
His grievance is basically this. Any new rate has to be acted upon with
The next
with the next quarter only.
so if he's basically saying that we've charged him more than what he needs to pay.
No, he's
that-
saying that, yes, basically that.
Basically, my lord, that issue can of course be gone into by the ombudsman. It is a statutory remedy, my lord.
Not my lord. Your lordship may see page 42. Now they are issuing another, my lord, regulation, which page 42. Now they are more clarifying it. Page 42, 4.2.
Yes.
Fuel and purchase power price adjustment shall be computed and charged by the additional agency in N plus 2 months on the basis of the actual variation cost of fuel and power purchase and state transmission charges for power procured during and month. For example, fuel purchase price adjustment surcharge on account of charge in tariff for power. supply.
Any representation made by you against this?
Yes, I have made my
Where-
lord. I made.
Where is that?
Yes, page my lord 36. My lord. Yes, I have. I made. The only point to be decided, retrospectively.
If we can decide it here, why should you go there? You
I'll leave it to my lordship.
obtain instruction.
They're only paying for issuance of notice, my lord. I'll file an affidavit, my lord. But my
Heard
lord, that
Mr.
issue may be kept open, but there is a alternate remedy.
Maintenance, okay, right.
Yes.
Heard Mr. G.S. Sahiwala, learned counsel for the petitioner who submits that that in terms of the Assam Electricity Regulatory Commission bracket fuel and power purchase price adjustment formula bracket close regulations, 2010 and the amendment of 2012, hereinafter referred to as the 2010 regulation, the the fuel price and power purchase costs can be recovered only from a new quarter in terms of
Regulations.
clause or what is it? Clause.
Well, that clause.
In terms of regulation 5.3,
Yes, 5.4.
5.4 and 5.5
Yes.
of the 2010 regulations. So he submits that despite the above, the respondents provide the impugned letter dated
27th May, page 31.
27/5/2023, bracket page 31, huh? Have fixed the rates, new rates with effect from June 23.
Energy consumed my lord from 1st of January, May.
It's from June 23 only.
Yes, but energy consumed is May 23 and well, from 1st of May.
In respect of the energy consumed during May 23.
Yes.
So Stafi submits that retrospective application cannot be given for charging of new rates in terms of the impugned notice, and the same has to be done only from a new quarter, that is July 2023.
Similarly, another notice is there at page 48, my lord. Same,
Page
page 48, for another quarter.
he submits that the subsequent impugned notice dated 29/9/2023, wherein new rates have been made from, new rates have been payable from October 2023 for energy consumed during September 2023 is also arbitrary. Issue notice returnable in 4 weeks. Mr.
Each other, my lord.
B. Chowdhury, Standing Council APGCL, accepts notice on behalf of all the respondents.
1, 2, and 3.
1, 2, and 3.
AIC is a separate entity, but they'll have their own council.
Okay, petitioner takes steps for service of notice upon the respondent number 4 by registered post with 80 within 2 days. Within 2 days.
Maybe 3 days, my lord, Sunday.
Within 3 days. List the matter. No, list the matter after 4 weeks. No, but actually, you just put the Mr. B. Chowdhury submits that the petitioner has an alternative remedy by way of section 42 bracket 6 of the Electricity Act 2003. And as such, he should avail the alternative remedy available. Then next at the end, you write that the issue of maintainability of the writ petition is kept open.
Well, 15 is same, my lord.
Item 50 is
15 is same, only name is different, my lord, name slightly.
Okay, dates, everything
Same,
same.
same.
Okay, 15 also same.
deeply read.
Apologies, Lordship. Item number 3, I was not able to appear because I was caught in the traffic. Lordship has recorded as non-appears.
Okay, item 3,
Item
Mr.
A. Sharma.
A. Sharma appears for the petition.
Notice has been issued. I've been understanding.
Noted.
Date may be kindly be given in the matter.
4 weeks.
If a
No,
date can be fixed.
no, the money suit, you also filed it after 4 years. You're in a hurry, suddenly you're in a hurry.
Okay.
The matter pertains to non-payment of contractual dues.
So we'll issue notice.
Yes.
I heard Mr. KP Pathak, learned counsel for the petitioner who submits that the contractual dues of the petitioner amounting to rupees 2,21,601 have not been paid. Issue notice returnable in 4 weeks. Mr. B. Gogoi accepts notice on behalf of
Respondent 200.
point number 2. While Ms. Adeka,
Number 13456.
you got it? The respondent's counsels shall obtain instructions and file affidavit if necessary. This is the matter out of 4 weeks.
Six same. The
Same.
respondents are, different department is different, respondent is stuff.
Okay, out here, the amount is 1,40,950. And Mr. B. Gogoi accepts notice on
Respondent number 2.
2 only.
Others.
Same.
Same.
Okay. Heard, Mr.
A to the lawsuit.
A to D. Now counsel for the petitioner who submits that the petitioner's outstanding bill of rupees 13,87,827 has not been paid. Issue notice returnable in 4 weeks. Ms.
And Bora,
N. Bora accepts notice on behalf of
respondent number 2, SCPNL.
respondent number 2. And Mr. G. Bokaral accepts notice on behalf of
1, 4, and 5.
1, 4, and 5. And Mr. R. Dubey accept notice on respondent. Same thing, huh? And that they obtain instructions of file affidavit, the same thing.
Much obliged.
What's the matter relating to non-payment of contractual payment?
Notice, Ms. S. Tutia accepts, learned counsel for the petitioner submits that the petitioner's contractual bill amounting to rupees 6,52,612 has not been paid. Issue notice returnable in 4 weeks. Ms.
And borderline for respondent number 2.
In borderline for 2, Ms. R. Deca for
Number 13456.
1, 3, 4, 5, 6.
No, 6 he is appearing.
Okay, 1, 3, 4, 5.
Yes.
Mr. G. Bokailal for 6, huh? The same thing, okay? Instructions and things.
This matter is also minor non-payment of contractual.
Okay, out here same Miss S. Tutia, huh?
Mala, I am praying for a similar order of this court, Mala, because this is under the FMP fund, Mala. This.
Where is that?
Mala, I have to elect, Mala, the order, Mala.
You will be having a copy?
Mala.
Give me.
But I don't need one.
Heard Miss S. Tutia, learned counsel for the petitioner who submits that the contractual bill of rupees 5,40,707 for the works executed by the petitioner under the scheme inverted commas, channelization of river Brahmaputra from downstream of Sarai Ghat Bridge to Gondmo area, inverted commas close, huh? Has not been paid to the petition. The petitioner's counsel submits that in a similar, in a series of matters, this court has given certain directions for realization for payment of the said amount. According, accordingly, no, she and accordingly prays for similar directions to be issued in this case. The case that the petitioner refers to is so, huh? Next para. Yes,
Lordship, my only submission is that the respondents should re-verify the amount.
they have to naturally.
Your Lordship. And the
They-
and the whole process will be completed within 6 months, Your Lordship. In the order, it is 4 months, Your Lordship. I prayed for 6 months, Your Lordship.
My order is already there, my lord, of this court.
Lordship.
Why is it not coming? Okay, then you write. Miss R. Deka, Learned Counsel for
For the water resource department.
the
Your
Water Resource Department and Mr. B. Goe for the Finance Department. Anybody else? Okay, Miss A. Gayal for fund number 1 and 3. Submit, all of them, huh? Submit that they have no objection to the prayer of the petitioner's counsel, provided that there is a re-verification of the amount payable to the petitioner. Full stop. Next, I have heard the counsel for the parties. In the case of not happening,
One more days for that. My, I will submit my after some time.
in the case of
4734/2021. 2021. Sorry, madam.
saving money, 3 rupees probably. Paper 3 rupees, I think.
Obliged, Your Lord. Obliged.
I remember one lawyer, long time back. He had spent 4 rupees in the IA court fee. He charged that also from his counsel from his client 4 rupees.
So 153 per day. Actually,
Huh? Oh, more than 150 page. But I want the first page, no, the first page. Oh, that's why she didn't take out a copy. 150 pages.
There's so many parties here. Lord.
Ah. What have, what, what have I said? What have I said? In the case of Nazim Hussain. Now, in a series of matters, the leading case being Nazim Hussain versus State of Assam and others, WPC 4734/2021, this court while disposing of similar matters have passed the following directions, which are as follows, huh? I put it here. Last. Next. In view of the consent of the parties and keeping in view the fact that where is the admission?
the page 15, madam.
And in view of the liability statement attached to the letter number GED/A-181/PT-Roman 2/19 dated 22/11/2022, issued by the Executive Engineer, Guwahati East WR Division, This court is of the view that the writ petition can be disposed of at the motion stage itself. In view of there being an admission made by the respondent number 5, comma, the respondents are directed to. The respondent number 4 is directed to re-verify and thereafter take a decision with regard to whether the amount claimed by the petitioner is an admitted amount. Full stop. In the event the respondent number 4 comes to a decision that the amount claimed is an admitted amount, comma, the directions passed in WPC 734/2021, comma, which have been enumerated above shall be complied with. The respondents are directed to complete the entire process within a period of 5 months.
3 months maybe. No.
I would say it says 4 months. Period of 5 months.
Right.
From today.
From the.
Okay, from the date of receipt of a copy of the sum.
Apply.
Writ petitions accordingly disposed of.
My lord, this is related to this non-issue of the tea subsidy to the tea garden. The
My
government of India.
In this matter, K. Gogoi will appear, my lord, need some time to, my lord, maybe pass over for the time being.
He doesn't want any stay order.
No, on notice, my lord.
Can it be disposed of or what? Why does he want to come?
He-
Can you wait?
in a way, after 5 or 10 minutes.
Okay.
I don't know.
Similar, 11 and 12, all three.
These are
All same. 12. Third, Mr. R.S. Chauhan, learned counsel for the petitioner, who submits that the petitioner has not been paid his contractual dues of rupees 2,84,042. Yes, what about it?
Yes, madam.
Notice, issue notice returnable in 4 weeks. Mr. B. Gogoi accepts notice on behalf of
my lord, respondent 1, 2, 3, 4, 5, all, my lord.
all respondents.
My lord.
He is accordingly directed to obtain instructions and file affidavit if necessary by the next day.
Yes.
This is the matter out of hold.
Obliged.
Here, manner earlier in the same issue, same subject matter, there are two round of litigations and both the litigations pending before this Honorable Court, manner. And in one of them, manner, there was a condition put up. It is regarding construction of a road under the PMJ scheme in Sonipur district. So my tent was cancelled, my work was cancelled, and now it is scheduled with another one. But the condition, my lord, where it was made by this court, was that any, depending on the outcome of this case. But that was not notified by the department and simply another one organization that was not registered organization was giving the work.
What was the order passed in the earlier case?
Yes, my you will have to kindly come through. Just a minute. Yes, yes, you are
54, my lord.
55. 55 is the ultimate order, my lord, where $54, my lord, please. There was though no order for in the restatement is passed, it is made clear that any action taken by the authorities in the meantime would be subject to the final outcome of the study petition. So these had to be notified to the whoever has now got the work, my lord, let him also know that there is litigation pending in the High Court, only two litigations are pending. And this will,
This is a continuation of the tender process. It
Ah.
will be subject to outcome automatically.
It says it is made clear that any action taken by the authorities
Yes,
in
will be
the
subject to-
meantime.
Yes.
So any future action would be subject to the final
yes,
outcome.
yes,
Even
So
when
we
we
issue-
the work order will be subject to outcome.
So we issue the notice.
Yes.
yes, yes. Well, Lordship will issue the notice, tag it with the other restrictions, my lord.
Lordship.
And my lord, that condition, let them notify to the contractor, next contractor. I want that.
No, he will, moment he gets a my lord copy of this particular petition, he will be aware of the.
Right. Heard, Mr. Heard, Mr.
Happy, sir, my lord.
R.P. Sharma, Leonard Senior Counsel, assisted by Mr.
Mansi.
R.P. Sharma, Leonard Senior Counsel, for the petitioner, assisted by Ms. M. Bora. The petitioner is agreed by the
Order dated 31/10/2023.
order dated
31/10/2023.
31/10/2023,
Yes. Page 55, 57.
issued by the Chief Engineer, PWD Border Road, instructing the respondent number
Phone number 8.
8 to proceed with the execution of the contract work. Full stop. The case of the petitioner in brief is that the petitioner had been awarded the contract work for construction of a road.
Yes.
Full stop. However, the contract was terminated by the authorities by termination order dated 19/7/22. Full stop. The petitioner had approached this court by by the WPC number 695/2023.
Yes.
Full stop.
No, there is
Where-
one,
Full stop. Wherein the order dated 8/2/2023 made it clear that any action taken by the authorities in the meantime would be subject to the final outcome of WPC 695/2023. That is at page 54, huh?
Yes.
Full stop. Full stop. Thereafter, the impugned order dated 31/10/23 has been issued, instructing the respondent number 8, who has been awarded the remaining portion of the contract work, to start the contract work. Issue notice, the same is under challenge, full stop, the same is under challenge, hearing. Issue notice returnable in 4 weeks.
For 1 mile.
Mr. B. Gogoi accepts notice on behalf of
3 to 7.
3 to 7. Mr. Name. KK Datta accept notice on behalf of respondent number 1. CGC. KK Datta. Huh?
Respondent 2, my lord, otherwise not a necessary party otherwise.
AK Datta. Mr. G.
My
Bokalal
lord,
for
Respondent 2, if I may be allowed, my lord, Chief Secretary, otherwise not a necessary otherwise. party.
Chief Secretary is not required at all.
Commissioner and Secretary PWD is already there, man.
Correct. Chief Secretary is not. Then you're
At
right.
this stage, at least.
No, Chief Secretary is not required at all. He's got
Unnecessary
nothing to do, unnecessary. Then you just say, issue notice to the respondent number 1, 3 to 8.
3 to 7.
Then 1 is AK Datta, then Mr. B. Gogoi for 3 to
7.
7. Petitioner to take steps for service of notice upon the respondent number 8 by registered post with AD within 3 days. This is the matter of the phone. The registry to tag this case along with WPC number 695/2023.
and there are other two.
695/2023 and
2781/22 and 4896/23.
just a minute. As there are two analogous matters.
Yes.
Come on. That is WPC number
2781 of 22
2781 of 22 and
and 4896 of 22.
4896 of 22, comma. The same, the present case should be tagged. Now, all the cases should be tagged together.
Along with, and my lord, that condition kindly,
What?
that subject to.
Okay, just right. Uh, any further action taken, the action taken by the issuance of the impugned order. No, the is subject to the outcome of the writ petition.
Lordship, similar orders were passed to the similar kind of matters. No.
This is not the issue, this is the challenge to the impugned order. Is subject. This further? Respondent,
2040 is a leading case, Your Lordship.
that is your case,
This is a leading case.
the leading case. No, what is this item, 7.2, what item?
16, Lord, 16.
Okay, what is this? I have not.
This is regarding imposing of forest royalty to the private individuals. also.
Huh?
Regarding of imposing of forest royalty to the private individuals. also.
Yes.
The concept, as the minor minerals concession rules were amended. Annex 1 Lordship, page 33.
Page 33.
Lordship. This is meant for government agencies only. And those who are license holders or leaseholders. And pursuant to that amendment, Lordship, the impugned letter was issued at Annex 4, page 41.
No, just show me the provision. Don't go to page only, just show
Lordship,
me the provision. Where's the provision?
Lordship, at page 33,
Yes,
amendment of Rule 5, number 2.
yes,
In the principal rules in Rule 5, for the existing the sub-rule 3, the following shall be substituted, namely, the minor minerals when shall be used or consumed by government departments, the rates of royalties shall be paid as per the rates prescribed in the third schedule appended to these rules, and other ancillary charges as shall be notified by government, shall be deducted by the government departments through the treasury in proportionate to the percentage of the total cost of project, excluding taxes as GST, IT, etc. The minor minerals when shall be used or consumed by government agencies, the rates of royalties shall be deducted as per the rates prescribed in the third schedule appended to these rules, and other ancillary charges as shall be notified by government at the time of payment of bills of contractors or suppliers in proportionate rate to the percentage of the total cost of project, excluding taxes as GST, IT, etc., and thereafter shall deposit in the appropriate head of account or bank account as shall be notified by government for the said purpose. The minor minerals when shall be used or consumed by the central government departments or any of their agencies, the rates of royalties shall be paid as per the rates prescribed in the third schedule appended to these rules, and other ancillary charges as shall be notified by government. Such departments or agencies shall ensure that prescribed royalties and ancillary charges have been paid by the contractors, suppliers, agencies before making final payment against their bills. Number 3, urban local bodies shall collect royalty as prescribed in the third schedule in 4 equal installments. The first installment shall be collected at the time of granting of building construction permission, the next 2 installments during construction, and the final installment on completion of the construction works. The royalties as collected by the urban local bodies shall be deposited into the head of account or bank account as shall be notified by the government. In rural areas, the existing procedure of making payments of royalties shall continue. Number 4.
Are you reading the entire thing?
No, the rates as appended in the third schedule and processed as prescribed above shall be applicable to fresh tenders only. Tenders are issued to the contractors only, not to the individuals. We are in
Contractors are individuals.
sorry,
Okay.
the government contractor.
Huh?
Government contractors only, those who have the license. Who participate in the tender process.
Correct, so.
We are private individuals. We do not participate. We are
So you
constructing
just go and take whatever you want.
no, we are constructing our own building, and we'll have to purchase from the tenderers only, from that leaseholders only. We will
Oh.
not directly procure the materials from the area, forest
We-
area.
So this 3 is for when it is consumed by the government, then the rates of royalties is as per the third schedule.
Third schedule.
Supposing it is not consumed by the government, then what is the rates applicable?
That is not mentioned.
No, not mentioned.
Appendix, third schedule, your lordship will find at page 36.
Yes.
And they are trying to collect the RCC building, RCC work 2%. That is number one. Work number one, RCC building, RCC work 2%.
Anything else?
Nothing else. Then they issued that impugn letter also, that's page 41. That it shall be.
So you are reading this amendment of section 5 only. That's
Right.
all.
5.8 and similar to it. 5.8 amendment of
Right.
rule 3,
Amendment
amendment of
wait.
rule 8, amendment of rule 27, similar. At 27 is at page 35.
Okay.
All these rules are applicable to the government agencies only.
Okay, but this is with this is with regard to the amendment rule. What does the main rule say?
Main rules also, it does not say about private individuals.
Okay, then let us see the office order.
Lordship at page 41, Lordship. This is subject is clarification regarding applicability of notification number so and so dated 7 October 2021. In continuation to this department's letter under reference and with reference to the subject cited above, I am directed to inform you that
No, just a minute. Clarification regarding applicability of notification dated 7/10/21. Where is the 7/10/21?
the early one, Annexure 1, Lordship. Annexure 1 amendment. Page 33.
Okay, that one, okay.
In continuation to the department's letter under reference and with reference to the subject cited above, I am directed to inform you that the meeting was held on 7/12/22 at 11 a.m. Conference of Honorable Minister Sendro, Mines Minerals Department and officials from both departments to discuss issues, difficulties faced by various departments in collection of forest royalty on minor minerals used for works of government departments, private builders. After discussing
Private builder?
these private builders is included. Pursuant to that amendment. After discussion, it was advised that no changes be affected in the notification so as well. And as such, this notification will be applicable in realization of forest royalties in both government departments, urban local bodies for both government and private agencies. These words are added, private agencies and private builders.
And what some judgment you have given?
Yes.
What is it?
The leading judgment is
Huh?
Similar matters have been
no.
listed.
The
Huh?
interim order.
Huh?
Interim order.
Interim one. Okay, this is interim one.
Challenging the same order.
Same notification.
And what is your order? What is this? You have given? Who is this?
This was a leading case, Your Lordship. That was filed first, challenging the 2023 order, Your Lordship. Whereby the interim was granted, Your Lordship. Staying this order, Your Lordship,
Ah.
2023.
So. Prima facie, it appears he has got a case. Heard, Mr.
D. Burwala.
D. Barwa,
Burwala.
learned counsel for the petitioner, who submits that the Assam Mineral Minor Concession bracket amendment rules, 2021 does not provide for payment of royalty by private builders who are not consuming the minor minerals for government works. However, while the impugned letter dated 2/3/23 issued by the Joint Secretary to the Government of Mizoram, Assam, Mines and Minerals Department, the word private builders / private agencies has been surreptitiously put into the said, they have been surreptitiously put in, to imply that the Assam Minor Mineral Concession Amendment Rules, 2021 is applicable for persons who are building their private buildings. issue notice returnable in 4 weeks. Mr.
Alright, Gogoi.
Accept notice on behalf of
Respondent 1 and 2, Your Lordship.
1 and 2. Then anybody else? Mr. S. Bora,
For 3 and 6.
3 and 6, and Mr. G. Bokailal for
4 and
4 and 5. Uh, list the matter after 4 weeks to enable the respondents counsel to obtain instruction file and file affidavit if necessary. In the meantime, the impugned letter dated 22/3/2023 insofar as it relates to private builders and private agencies will remain state.
The matter be tagged with 2040.
Till final disposal of the case. Let this matter be tagged with WPC 2040/2023 and 6507/2023.
Public.
Motion 45.
The matter may be taken up after some time, then. Senior is on the way. After some time.
46.
This is an application under 26 of the Constitution of India.
Hmm?
So it is regarding recruitment of teachers. Oh, I'm sorry.
There's something, contract matter.
Contract. Dear my lord, the contract was awarded. Impugned order is 70.
So we'll issue notice, that's all. Then nothing can be done beyond that.
No, we don't actually. We have already challenged the conduct.
Maybe,
Then the-
but without any ground.
No, my lord.
You want the reasons for the challenge. You want the reasons for awarding the settlement or the contract to them.
Yes,
Now, so as on date, you don't know on what grounds to challenge them, except by saying that they do not fulfill the tender specification. Now, what do they don't fulfill? I don't.
no, this is the final order. We have already filed a writ petition against the tender. Your lordship may see the 60 original by single judge. Page 60. 60.
60. Well, 60.
60, my lord.
Yes.
Lordship may kindly come to page 62.
Yes.
62, my lord. Issue notice making it retirable on 2/2. The petitioner is directed to take steps upon the response number 1268. Registered post ID as well as usual process during the course of the day. Further to that, the court directs the respondent to take steps upon the response number 4 and 8 by way of dossier routed through the registry of this court and file an affidavit of service on or before the said date. The case of the petitioner herein is that the petitioner along with 2 others had participated in the tender dated so and so for supply, fixing, testing, and commissioning SITC of LED floodlight in Dampa Tiger Reserve Forest. area from near BP number so and so, so and so. It is the further case of the petitioner that as per the eligibility condition, which is stipulated in clause 20 of the notice inviting tender, that the work experience mandates that the tenderers must have completed similar works during the last 7 years, ending initial stipulated last date submission of the tender. It is further stipulates that there is to be 3 similar work, each costing not less than 40% of the estimated cost put to the tender, or 2 similar works, such costing not less than 50% of the estimated cost put to tender, or 1 similar work costing not less than 80% of the estimated cost put to the tender. It is the further case of the petitioner that the powers have clause 2 of clause 2A. The past experience in terms of clause 2A has to be adjudged on the basis of the certificate issued by the direct client organization. However, in the case of the work experience pertaining to the private sector, the completion certificate shall be supported with copies of the letter of award and the copies of corresponding TDS certificate, and the value of the award be considered equivalent to the amount of TDS. The record further reveals that the petitioner, along with 2 other tenderers who are the respondent number 7 and 8, duly participate in the said tender notice process. At the time of evaluating the technical bid, the petitioners were duly held to be qualified along with the respondents 7 and 8. The petitioner duly objected the same. However, the technical committee did not consider. It is the specific case of the petitioner that the respondent number 7 and 8 do not have the technical qualification. Be that as it may, the price bid was duly opened, whereby the respondent number 8 is the lowest bidder and the respondent number 7 is the second lowest bidder, followed by the petitioner, who is the third lowest. It is the specific case of the petitioner that the respondent number 7 and 8 did not meet the qualification. However, the respondent authority are taking steps for the purpose of setting the said tender in favor of the respondent number 8. The court for the present is not issuing notice upon the respondent number 7, taking into account that primary grievance of the petitioner is against the respondent number 8. The respondents, more particularly the respondent to 1 to 6, as well as the respondent number 8, shall apprise this court on the next date as to the whether the respondent number 8 duly qualifies the terms with clause 2(a)(1). The court for the present is not inclined to pass any interim order. The interim order shall be considered on the next returnable date. The court, however, observed that if any order is issued to the respondent number 8 in the meantime, the same shall be subject to the outcome of the pressure. Now the final order is passed by the government, which I pointed out to them. So at this stage, my lord, this matter also would be tagged together and notice may be issued.
Right. Heard Mr. A.K. Bhattacharjee, learned senior advocate. Assisted by, for the petition, assisted by Mr.
H.
Huh?
H.
H. Burra, go ahead. Yeah, for the petitioners, huh? For the petitioners, so sir. The petitioner is aggrieved with the issue of the letter of acceptance, is it?
Letter of award,
Letter of award dated
31/2024, my lord.
Page 7.
31/2024. In favor of the respondent number
7 is the current petition, my
Huh?
The 7, my lord.
7.
Current
Who is the 8 in the other representative?
other
In favor of the respondent number 7. Who is also the respondent number 8 in WPC number 434/2024. Yes, sir. The petitioner's next para. The petitioner's case is that The respondent number 7 has been awarded the contract work in pursuant to the NIT dated. NIT dated
12,024, madam.
NIT dated 10/11/2023. Which has been put to challenge in WPC 434/2024. However, by the impugned letter of award dated 30/1/2024, the respondent number 7 is going to start the contract work. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondents by a registered post with AD within 3 days. Leave the matter after 4 weeks tag this case along with WPC number 434/2024. The letter of award dated 30/1/2024 issued to the respondent number 7 shall be subject to the outcome of the writ petition.
Highly obliged.
Yes,
Sir, please, Lordship, we have taken steps
when?
yesterday and
Yesterday.
respondent number 1 is pending. We'll take it today, Lordship. This file was misplaced. Lordship.
1 was not required to be taken, only 3 is required to be taken. 1 was already represented.
3 is also written, Lordship. We have served a copy to.
Extra copy will be today they have served.
We are appearing for 3.
Yes, yes.
Okay. Then Mr. R. Dubey accepts notice on behalf of, appears on behalf of respondent number 3. Appears on behalf of whom? Only 3 or what?
Yes, State Election Commission.
Only that. Appears on behalf of respondent number 3 and submit that he will submit a vakalat number. Is it required? Standing counsel
Yes, yes. But they have to serve extra copy. That was not done.
submits
But
that,
they have
submits that he'll be appearing for respondent number 3. To stop, Miss
And Bora,
Ann Bora
as secretary for respondent number 2.
2 appears for respondent number 2, while Miss G. Bokalal accepts notice appears on behalf of 1 and 4. Extra copy be provided to Mr. R. Dubey. Oh, petitioner to serve extra copies of the writ petition to the counsels for the respondent. List the matter after 4. What do we do? List the matter after 4 weeks.
After 4 weeks, Lord. 18, same Lord. Same Lord.
I don't see. Your position in the cost title is also same.
Yes.
See,
Much.
same one.
I think 19 for admission.
Yes, what happened, madam? What is your instruction?
Lordship, we have communicated with the department, but not received till now.
Last chance was given.
Lordship, kindly,
No one appears for the petitioner. Miss N. Bora submits that she has not been given instructions as on date and accordingly prays for some more time. List the matter after 3 weeks. Yes,
Lordship, hearing this matter, yesterday I have filed an affidavit on behalf of the respondent number 3, Lordship.
so what effect? So what did you file? What did you say in your affidavit?
Lordship, there are many complaints against the petitioner, Lordship, and the norms are not followed by him.
Okay,
To
so
maintain
you
the-
file, let us get it there. It's not here.
Lord,
Are you admitting the amount?
no, Lordship.
No.
Such a permission.
Not admitted. If it's not admitted, what to do? Then you've got no,
My lord, I will file a reply, my lord.
you have to file reply.
My lord.
Okay,
So,
uh,
on the 3 days
Mr.
may be granted, my lord.
Huh?
3 days may be granted, my lord, and my lord, that may be fixed, my lord. We have,
No
my lord,
need,
any,
no.
and we have incurred, my lord, now, my lord, 1 crore 26 lakhs, my lord.
When did you, this contract work was done when? Supply order issued when? When was it done?
Yeah, kindly see, my lord,
Pertains to which period?
uh,
Which year?
15, 16, 17, my lord, continuing, my lord.
15, 16, 17.
Yes, my lord. Kindly see page, my lord.
And you filed this, and why didn't you go for, why didn't you go to the civil court? Why didn't you come to this court earlier? You came in 2022,
My lord, my lord,
and now you are in a
process, my
sudden
lord,
hurry.
then in 2018, my lord, because my contract, my lord, the
Right.
contract was not having a part, my
Mr.
lord, because non-payment
Triple
of
S
contract-
Raman, learned counsel for the petitioner, submits that he has been given a copy of the affidavit in opposition and would like, how much weeks?
3 days, my lord.
Uh,
On
uh,
Monday, we'll file.
I would like a week's time to file his affidavit in reply. Praise the Lord, this is the matter after a week.
My lord, the date may be fixed, my
Not
lord.
it.
21 and 22.
But in this matter, final opportunities were granted to the PWD department on 3 occasions, and on 5th of February, they were directed to file an affidavit positively by 6th of February. On 7th of February, due to paucity of time, the matter could not be taken up, and it was directed to be listed today. And on many occasions, the PWD councils remain absent in these matters. And this is from this matters is the second,
Is the affidavit here?
no, they have not filed affidavit. And the matter pertains to 2001. The work completion
Where
certificate.
is this Miss Das?
Many people appears, Mr. Gogoi was last appearing in this matter. But today also even, every time when the matter is called up.
Let
they
us see,
remain-
what is
Yes,
your case here?
Malad, the petitioner was awarded with the contractual work,
With the,
and he has earlier filed a writ petition for non-payment of dues. Your lordship will find page 70. The
page
first,
17.
the order dated 24/6/2011.
Yes,
This writ petition was disposed of in the light of.
just a
this
minute.
counsel-
Let
counsel
us
order.
see, let us see that what is written here.
Yes, my lord. Page 17.
But
My lord, Mr. B. Gogoi is arguing in another court, my lord.
where is Miss M. Das? Miss Das, where is Miss Das? There is one Das who had appeared last time. It's Mr. Gogoi Junior or what?
He's junior, my lord.
Junior. He's coming, Mr. Gogoi is coming. We're disposing this off, whether he comes or not.
Then, my lord,
Just a minute. So this order was passed then?
then a demand regarding the fund was placed on 19 next day next year, on 19/1/22. This is an admitted amount.
22 lakhs, 67, okay.
Then the next page
But
is,
you see, very interesting.
yes,
This letter does not have copy to.
it was,
Anyway, then
then I have annexed the completion certificate, page 22. Work was completed on
2002.
On 19, what is this date?
Date of completion 2/5/2002.
Completion certificate dated. I want the completion certificate. When was it issued?
It was issued on 15/1/2022.
15/1/2022.
And
And date of completion was 2002.
2002.
What is this? How can it be?
No, earlier they also given for the purpose of
What?
this, purpose of
How-
this.
How can they verify after 20 years?
No,
There is
madam.
something wrong.
After, for this demand proposal, they have prepared this again, once again. For submitting the demand, they have also they have prepared this completion certificate. Earlier litigation, they have already given the completion certificate. This is a part of this demand proposal, this demand proposal.
This is not correct. Your writ petition
Yes, madam,
that you filed was in 2011.
yes.
So where is the completion certificate prior to the 2011
That
writ
was,
petition?
that was there, madam. That
Where was it? Show me. Only there was there.
Here it is.
Show me. If you
Because-
said there was there, where is it? Don't just try to brush things under the carpet, Mr. Counsel.
My lord,
If it was there, then show me.
the earlier,
Show me. Wherever.
just
Yes,
Yes, it
then
is.
after that,
I have, my lord.
yes, show me.
Your lord. It's-
Is there a part of the pleadings here?
No, my lord, this is an admitted amount. Earlier set of litigation, they have admitted.
Where
that-
have they admitted?
My lord, this order, they have said that their repetition of disposed of, uh, uh, with the deal with the grievance of the petitioner. And now they have admitted by,
Mr. Counsel, I think even I can read it. It says what? It says here, in view of the above, the petition disposed of with the directions as a petition as well as the response shall be bound by the principle of law and directions as passed in Tamsher Ali.
even in
Now, what does Tamsher Ali say?
they prepared a list of the,
Tamsher Ali only says basically that it has to be certified by the chief engineer. Where is that certified by the chief engineer?
yes, my lord, page 26.
26.
Page 26 of the writ petition. Demand was also certified by the chief engineer. Below that
Just a
signature,
minute. This is the things are completely, they're not matching each other. Date of commencement, date of completion, not matching each other.
probably, my lord, this is regarding some other work.
What? Some other work, then why are you giving me some other work?
My lord, I'll just check. I'm in a hurry, I'm sorry.
It is there, my lord. Sorry, my lord, I'm sorry. There are two cases. In fact, there are 4 cases. It is there.
Name of contractor is also different. One is
I'm sorry,
Pradeep
madam.
Kumar Das, one is Pawan Changmai.
I'm sorry, madam. This is the right one.
Now here also there's a mistake. Date of completion is different. No, this amount is different. When was this issued?
My lord, this was issued after the completion. I don't know the date. But my lord, one thing, if you
You
not,
see, one thing is very clear. It was done after a long time because it says here. This certificate has been issued as per office record available in the office. The work was completed long back. Hence, physical verification of the scheme at present is not possible.
my lord, lordship will see.
So that is why this completion certificate is not prior to 2011. It doesn't appear to be.
My lord, page 26 of the repetition may kindly table. Page 26.
Yes.
This is the ceiling proposal.
Huh?
Ceiling proposal, 26. Purpose, name of the scheme, demand of fund against court case number WPC 3217/2011. Pradeep Kumar Rao, so and so, for submission of finance budget section. Lordship will see that page 17, the repetition number is 3217. And this was issued, countersigned by the senior FAO, Office of the PWD, and head of the department, that is chief engineer. And the
Then what
amount,
else? Besides that, then
thereafter, the deputy secretary of the Public Works Department asked for page 27 for genuineness of the claim. Page 27,
then
then 28, page 28. The chief engineer writes to the executive engineer to provide the genuineness. Then page 29. Page 29. Paragraph 1, the petitioner satisfactorily completed the work, so the claim is genuine as per records of this division. The payment is due to the petitioner in terms of Tamsirali. A demand proposal was submitted to superintending engineer, road circle, so and so, case number so and so, dated 23rd of December 2011.
okay. Yes, we are waiting for Mr. Gogoi.
My lord. Lordship may fix it on Wednesday, then.
No, no. Again, going through the same thing.
Madam.
No,
And we.
we'll try and dispose it off. Yes. What is your case?
My lord, in this case, the Ministry of Industry and Commerce Department issued a scheme, tea development promotion scheme for tea estates. And accordingly, I undertake the plantation as well, the contractor may have production to orthodox tea. Orthodox tea production.
Tea production. So,
So I filed my application for subsidy, so sanction of subsidy
Not, not decided.
not decided.
My lord, may issue notice at the state laws. Otherwise, lordship, just by point out, lord, there is no resolution of the board resolution. It says that it's a company lordship. Or just technical issue, otherwise a curable defect lordship. There is
Board resolution is internal.
board resolution is required for filing a petition of lordship.
No, my lord, that is their internal matter,
No.
that they have their
That-
own,
That should be
that
lordship.
is subjected.
Anyway, those are different issues.
Otherwise,
The main issue is that whether there is a subsidy, whether there is a
that
scheme,
part
whether
is
he is
there.
entitled to it and whether he
Yes.
should get it. That's all.
That part is there. Otherwise, those in the honorable apex in the Travancore cases,
Huh?
honorable apex in the Travancore cases, it is says that lordship, there should be a board resolution lordship.
There is there, that
Yeah,
is there.
And then you bring the board
Yeah,
resolution.
that is there,
It is-
there will be some,
If it's lordship.
it's an internal matter.
Right, lordship, then there should be a board resolution.
Board resolution is an internal matter. So
Oh,
it
yes.
is not compulsory that is to,
Correct.
unless there is a board resolution that can be.
Otherwise,
Unless it is
lordship,
disputed.
I am not disputed. What is the law? Just I have placed lordship.
No, actually,
Paragraph
that is,
14 lordship, paragraph 14.
kind of, there is a provision also. Is a doctrine of internal management. Whatever resolution that is,
Kind of
that is
management
an
is
internal
there.
matter.
I am not saying that there is not.
Okay, right. Heard, Mr.
These are.
This I will learn counsel for the petitioner who submits that though the petitioner has applied for the subsidy by applied for the subsidy in terms of the
Yeah.
Tea Development and
Development
Promotion Scheme
Scheme.
for Medium Term Framework
Yeah.
issued by the Ministry of Commerce and Industry Department of Commerce to the Government of India. Where is that? Where is the scheme?
Steve, the page number starts, 18. Steve starts from 18. And
Uh,
page number 50
This is for which period?
is period from, starts from 29/12/2007 to 31st March 2010.
Which is from 29/12/2007 to 31/3/2020, comma. The same has not been considered by the respondents till date. Issue notice returnable in 4 weeks. Mr. King, I accept notice on behalf of
Lordship, I have all the respondents.
all the respondents. Leave the matter after 4 weeks. All right, Lordship.
Same issue.
11,
And
12,
12
same.
also.
11 and 12 same lordship.
My lord, this is an application under section 11 for appointment of arbitrator.
Yes,
They have not filed any counter affidavit till today.
maybe they are not objecting.
It will be treated that they are not objecting.
My lord. There is one stand here taken that claims beyond 20% of the value of the contract has to be decided by a civil court in terms of clause 64.7.
That is a invalid clause, my lord. Because your lordship may kindly, this is not a arbitration clause. This is beyond the arbitration clause.
There is,
It means beyond the arbitration agreement.
Notice parties have agreed to it, my lord. This clause.
Your lordship may kindly come to page 48, my lord.
40, yes.
The arbitration agreement or arbitration clause
Yes,
is 10.0. Settlement of dispute and Indian Railway arbitration rules. Arbitration and settlement of dispute shall be governed by clause 63 and 64 of General Conditions of Contract, NF Railway, 1998 edition, which are reproduced below subject to any correction made prior to the opening of this tender. Now 63, my lord.
yes.
This is the arbitration clause. Matters finally determined by the railway, all dispute and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the railway. And the railway shall, within 120 days after receipt of the contractor's representation, make and notify the decision on all matters referred to by the contractor in writing, provided that matters for which provision has been made in clause so and so of general conditions of contract or in any clause of the special condition of the contract shall be deemed as accepted matter, and decision of the railway authority thereon shall be final and binding on the contractor, provided further that accepted matter shall stand specifically excluded from the purview of the arbitration clause.
Yes, yes.
And
Look, this matter. You put it in that big over, we were waiting for big over, you know, that one, that matter just before this.
That's 21, 22.
21. Is it 21, 22? Yes, yes. Huh? Yeah, by you, by him. By you. I know, just a bit. Yes,
now, my lord, second part, clause 64(1)(1) is the procedure for appointment of arbitrator. Now, your lordship may turn to page, next page, my lord.
just a minute. Yes,
Now, the clause number 10.1. This is a, on all, clause 10 is the arbitration clause.
yes.
Clause 10.1 is not arbitration clause.
10.1, where do you get 10.1?
At page 51, my lord.
Page 51.
Yes.
Yes,
10.1, my lord,
yes,
which they are saying.
yes.
Now, my twofold argument is there. First, my lord, my submission is that this is, whether this is valid or not valid, this is valid or not valid, it should be adjudicated by the arbitrator. On that point, my lord, first I am making my submission. Your lordship may kindly come to this arbitration act, my lord. Now, after the amendment of 2015, my lord, a subsection 6A was included, which is
Mr. Counsel, the issue is not that. The issue that has been brought out by him is when the dispute relates to 20% of the contract amount, then that has to be decided by the civil court and not by way of arbitration.
my lord, I will satisfy your lordship, my lord. This section, subsection 6A, your lordship, by kindly.
Subsection,
6A,
where is 6A?
this is
Okay, you mean in the Bear Act,
in the Bear Act, my lord.
subsection 6A of?
6A is omitted by 2019 amendment.
But it is still valid, my lord, because notification has not been issued.
Huh?
Notification has not been issued
What notification?
for the deletion of this section, subsection 6A.
Has been
Let
omitted
me
by the
complete,
2019.
I will satisfy your lordship. 6A, your lordship, by kindly.
Just a minute. I don't have 6A, 15.6, what?
After the amendment of 2015, my lord, subsection 6A was inserted. Before that, it was not there.
6A. I don't have it in my book.
Because that was amended, my lord. My lord is having the amended one. Well,
This was amended in 2019, omitted, but still notification has not been issued. And there is a, in this respect, there is a judgment of the Constitution Bench, Honorable Constitution Bench, Honorable Supreme Court. Very important judgment it is there.
Judgment dated?
Judgment, my lord, very recent judgment, my lord, dated 13 December 2023. Constitution Bench. In interplay between arbitration agreement under the Arbitration and Conciliation Act. Constitution Bench judgment.
With the Stamp Act, is it?
Yes,
5 judges bench.
I have.
Replace the Arbitration Act with the Stamp Act. Is that the one you're talking about?
Yes, my lord. But here the important. Your lordship may kindly come to page 40,
Para?
my lord, 16.1. The 2015 Amendment Act has let down different.
Just a minute. There's no pagination first of all and 16.1.
Yes, my lord. On the head paging is there, page 40.
There is no 16.1.
Page 40, your lordship may see. SCC online, then second on the head, on the top of the page, my lord.
There is no pagination. Page 40.
40, my lord.
There's no pagination.
On the top of
Which
the
para is it? Which para?
page 16.1.
Page 16.1?
No, sorry, my lord, 161.
160.
Yes. Sorry,
That page, that para 161 you mean?
161. There is lordship. The 2015 Amendment Act has laid down different parameters for judicial review under the Section 8 and Section 11. Where the Section 8 requires the referral court to look into the prima facie existence of a valid arbitration agreement. Section 11 confines the court jurisdiction to the examination of the existence of an arbitration agreement. Although the object and purpose behind both Section 8 and 11 is to compel parties to abide by their contractual understanding, the scope of power of the referral court under the said provision is intended to be different. The same is also evident from the fact that Section 37 of the Arbitration Act allows an appeal from the order of an arbitral tribunal refusing to refer the parties to arbitration under Section 8, but not from Section 11. Thus, the 2015 Amendment Act has legislatively overruled the dictum complementary in nature. Accordingly, the two provisions cannot read as laying down a similar standard. The legislature confined the scope of the reference under Section 11(6)(a) to the examination of the existence of an arbitration agreement. The use of examination in itself connotes that the scope of power is limited to a prima facie determination. Since the arbitration it is self-content, the requirement of existence of an arbitration agreement draws effect from Section 7 of the Arbitration Act. In Duro Felgure, this court held that the referral courts only need to consider one aspect to determine the existence of an arbitration agreement. Whether the underlying contract contains an arbitration agreement which provides for arbitration pertaining to the dispute which have arisen between the parties to the agreement. Therefore, the scope of examination under Section 11(6)(a) should be confined to the existence of an arbitration agreement on the basis of Section 7. Similarly, the validity of an arbitration agreement in view of Section 7 should be restricted to the requirement of the formal validity, such as the requirement that the agreement be in writing. This interpretation also gives true effect to the doctrine of competence by leaving the issue of substantive existence and validity of an arbitration agreement to be decided by arbitral tribunal under section 16. We accordingly clarified that the position of law laid down Vidya Dorolia in the context of section 8 and section 11 of the Arbitration Act. Now, here this, your lordship may kindly come to paragraph 155. In Mayawati Trading versus Pradyut Dev Burman, a three-judge bench of this court affirmed the reasoning in Duro Bulgara by observing that the examination under sections 11(6) is confined to the examination of the existence of an arbitration agreement and is to be understood in the narrow sense. Moreover, it held that the position of law prior to the 2015 amendment that as set forth by the decision of this court in Patel Engineering and Bogara Polyfab has been legislatively overruled. Thus, this court gave effect to the intention of the legislature in minimizing the role of the courts at the pre-arbitral stage to the bare minimum. Thereafter, in Vidya Dorolia, another three-judge bench of this court affirmed the ruling in Mayawati Trading that Patel Engineering has been legislatively overruled. In Vidya Dorolia, one of the issues before this court was whether the court at the reference stage of the arbitral tribunal in the arbitration proceeding would decide the question of non-arbitrability. This court begins its analysis by holding that the arbitration agreement has to satisfy the mandate of the Contract Act. In addition to satisfying the requirement stipulated under section 7 of the Arbitration Act to qualify as an agreement. Now, the section, your lordship may come to this paragraph 158. At the outset, Vidya Dorolia noted that section 11 has undergone another amendment by Act 33 of 2019 with effect from 9/8/2019. The purport of the omission of the said clause was further explained in the following terms. Omission of subsection 6A by Act 33 of 2019 was with the specific object and purpose and is relatively to by substitution of subsection 12, 13, 14 of subsection 11 of the Arbitration Act by Act 33 of the 2019, which wide subsection 3A stipulate that the High Court and this court shall have the power to designate the arbitral institutions which have been so graded by the council under section 43(1), provided where a graded arbitral institution is not available, the High Court concerned shall maintain a panel of arbitrators for disregarding, discharging the function, and thereupon the High Court shall perform the duty of an arbitral institution for reference to the arbitral tribunal. Therefore, it would be wrong to accept that post omission of subsection 6A of section 11, the ratio of Patel Engineering would become applicable. Vidya Dorolia proceed on the presumption that section 11(6)(a) was effectively omitted from the issued book by 2019 Amendment Act. This is also reflected in the conclusion arrived at by the court, as is evident from the following extract. Ratio of the decision in Patel Engineering, so and so on the scope of judicial review by the court while deciding an application under section 11(8) or 11 of the Arbitration Act post the amendment by Act 3 of 2016 with retrospective effect from 23/10/2015 and even post amendment wide Act 33 of 2019 is no longer applicable. We are of the opinion that the above premises of the court in Vidya Dorolia is erroneous because the omission of section 11(6)(a) has not been notified. It is still there, my lord.
What does 6A say?
6A says, my lord, only the court will see whether arbitration agreement is there or not. Arbitration, there is no dispute about the arbitration agreement, clause 63, my lord. Other entire matter shall be referred to the arbitrator. Arbitrator should decide under section 16. They can raise, because some of the claims is arising out of the contract. Some of the claims is relating to the breach of contract. They cannot say we cannot make the claim of breach of contract. That is also included. And in this respect, your lordship may kindly order I am referring, my lord, of this honorable court, my lord. Even prior to amendment of 2015, my lord, this issue was raised in a case, my lord, same party, my lord. And this honorable court appointed the arbitrator, they approached the honorable Supreme Court dismissed their petition. Even prior to the amendment of the 2015.
This is not in your favor.
Now,
This is not in your favor.
this is not against me also, my lord, because the appointment arbitrator was appointed.
You
by-
see, it says here, I am satisfied that the claimed amount is so and so, which is less than 20% of the contract amount.
Yes, because the 2 lakh was included, which was relating to the.
Whatever it is, so this court's held that since it is less than 20%, that's why a contractor was appointed, arbitrator was appointed.
Now, about this, their contention regarding this 10-1, my lord. That is invalid in the eye of law. And in this respect, my lord, I am referring one very good judgment of the Honorable Delhi High Court, which
I am bound by this High Court, not by the Delhi High Court.
so many Supreme Court judgment is also here.
Then you give me Supreme Court, don't give me Delhi High Court. No point. I am bound by by a coordinate bench of this court. Unless you can prove, you can convince me otherwise.
My lord, even after issue of notice, my lord, they received the notice, they failed to appoint the arbitrator.
I'm not on that.
Now-
You go to civil court, Mr. Counsel.
No, I am coming to that, my lord. Let me complete, my lord. I am coming. This, my lord.
Can
is
you
the-
please come to the point?
Yes, I am coming to the point, my lord. Then I am referring this, my lord.
Hmm?
Lombardi Engineering Limited versus State of Uttarakhand. In this,
Give me the, that, 6A. 6A, section 6A of the Arbitration Act, which has been omitted but which the Supreme Court has said that it is still in operation. Omitted in 2015. Yes,
Next page, my lord. First page is there, next paragraph.
yes, after first page, it should be the next page. So,
Yes,
yes, I'm in the
Paragraph
next page.
53.2, my lord.
33.2, yes.
Yes. The contractor shall sum the details of his claim in writing, including. I am skipping this, my lord. Then your lordship may come to clause 55, arbitration clause. Yes.
55,
Yes.
yes.
All the disputes and the question and disputes relating to the meaning of the specification, design, drawing, and instructions herein, and as to the quality of workmanship or material used on the work, or as to any other question claim, right, matter, or thing whatsoever in any way arising out of or in
No, not
relation
the
to the
judgment.
contract,
In the
design,
arbitration,
drawing,
that
specification, estimates, instructions, orders for these conditions or otherwise concerning the work or the execution or failure to execute the same, whether arising during the progress of the work or after the cancellation, termination, completion, and amendment thereof, shall be conducted in accordance with the provisions of the Arbitration and Conciliation Act 1996, or any statutory modification or reenactment thereof, and the rules made the under and for the time being in force shall apply to the arbitration proceeding. However, the party initiating the arbitration claim shall have to deposit 7% of the arbitration claim in the shape of fixed deposit receipt as security deposit. So here this condition was there. Now,
what condition? What condition?
condition for depositing 7% of the claim amount as a security. Illegal, invalid condition was there.
That's a different issue.
If issue is different, my lord, but the Honorable Supreme Court, your lordship, might then kindly come to page.
That has got nothing to do with the issue that is that we're deciding now. Whether your matter should be referred to an arbitrator by appointing an arbitrator, or it should be dismissed with liberty to you to go to civil court.
My humble submission is that the arbitration, there is no prohibition in the arbitration clause or arbitration agreement. Clause 10.1 is void in the eye of law because there is no pecuniary limitation of the arbitration in the Arbitration Act.
And the Arbitration Act, actually, there won't be any pecuniary.
Yes.
You have put this condition on yourself. You have imposed this limitation on yourself by agreeing to that.
Any condition, my lord, is subject to law of the land, my lord.
So show me some judgment which says that 10.1 is void or.
All the railway contracts, hundreds
Huh?
of contracts having same condition.
I know,
And
but
railway
there is
My
no.
lord, they have not filed any affidavit. On
On
what
the
ground?
council, you have to stand on your own legs. You can't expect to stand on their weakness or just because they have not submitted
There
an
is no
affidavit.
pleading, my lord.
Mr. Council, please understand one thing. You are relying upon 64. If you are relying upon 64, you have got to show me that your application comes within 64 fully in toto. However, there it says, 10.1 says that if your claim is 20% and above, it has to go to civil court.
That is, my lord, I am trying to satisfy your lordship that clause is void in the eye of law. It is illegal.
Yes. Tell me, how much is your claim? How much is your claim?
Now the claim is 1,86 lakhs, my lord.
And
23,336.
123,000,
1,86 lakhs, my lord.
23,000,
336.
336.
Yes.
Any paisas? No paisa.
0.78, my lord.
0.78.
0.7.
And what is the contract value?
Contract value, my lord.
Contract value is, my lord, 5 crores, 7 lakhs.
5 crores, 7 lakhs.
69,700.
7 lakhs, 69,000,
700.
7?
700.
No, 4 crore. 36.
No, it's better if it's 5 crores, Mr.
34, I am on 36.
Item number 34, arbitration petition.
5 lakhs 0769,700, correct?
My lord.
So it comes to, so this is basically, it comes to how much percent? More than 20%,
36.68%, my lord.
36.68%. Okay. And yes, Mr. Anything else? to say?
My lord, I would just like to, my lord, submit the. My lord, on the issue of the scope of the, my lord, the court under section 11 at pre-referral stage. My lord, there is a recent judgment of the Supreme Court. 2023. Because my London friend has pointed out 6A, my lord, to show that the scope of section 11 court is only to
Look into that,
look
yes,
into the arbitration agreement.
yes.
But this judgment, my lord, held that, my lord, the court can.
No,
go
that,
into-
that it'll be on the facts and circumstances of that case.
Yes,
The issue was not with regard to, the issue that was, the issue that was not brought out was with regard to what is being decided here. That was not an issue that was decided there.
my lord. So, my lord, what is the scope under
Okay.
section 11, my lord? To that aspect, my lord, paragraph 25, if I may read, my lord, the Supreme Court judgment,
Yes,
paragraph 25, my lord.
yes.
The above referred precedents crystallize the position of law that pre-referral jurisdiction of the court under section 11(6) of the Act is very narrow and inheres two inquiries. The preliminary inquiry is about the existence and validity of an arbitration agreement, which also includes an inquiry as to the parties to the agreement and the applicant's privity to the said agreement. These are matters which require a thorough examination by the referral court. The secondary inquiry that may arise at the reference stage itself is with respect to the non-arbitrability of the dispute. So therefore, my lord, my submission is that the parties to the contract have agreed and the contract is binding upon both the parties.
Correct.
And
That is a subsisting clause,
yes,
which is a valid clause, and there is no challenge to that clause.
no challenge to that clause. And these standard documents are, my lord, formulated by the railway board, my lord, after thorough
Formulated by whoever.
examination.
However, how does it matter?
My lord.
We're not on that issue.
So, my lord, my submission is, regard to this is that, my lord, and subsequently in paragraph 28,
Just a minute. 26,
Paragraph-
what does it say? 26?
26, my lord, as a general rule and a principle, the arbitral tribunal is the preferred first authority to determine and decide all questions of non-arbitrability. As an exception to the rule and rarely as a demurrer, the referral court may reject claims which are manifestly and expressly non-arbitrable. Explaining the position of law flowing from the principles laid down in Vidra Dolia, this court in a subsequent decision in Nortel Networks held. While exercising jurisdiction under section 11 as the judicial forum, the court may exercise the prima facie test to screen and knock down ex facie meritless, frivolous, and dishonest litigation. Limited jurisdiction of the court would ensure expeditious and efficient disposal at the referral stage. At the referral stage, this court can interfere only when it is manifest that the claims are ex facie time barred and dead, and there is no subsisting disputes. Then, my lord, at paragraph 28,
27?
27, my lord, the standard of scrutiny to examine the non-arbitrability of a claim is only prima facie. Referral courts must not undertake a full review of the contested facts. They must only be confined to a primary first review and let facts speak for themselves. This also requires the court to examine whether the assertion on the arbitrability is bona fide or not. The prima facie scrutiny of the facts must lead to a real conclusion that there is not even a vestige of doubt that the claim is non-arbitrable. On the other hand, even if there is a slightest doubt, the rule is to refer the dispute to the arbitration. The limited scrutiny through the eye of needle is necessary and compelling. It is intertwined with the duty of the referral court to protect the parties from being forced to arbitrate when the matter is demonstrably non-arbitrable. It has been termed as a legitimate interference by the court to refuse reference in order to prevent wastage of public and private resources. Further, as noted in Vidra Dolia, if this duty is
within the limited compass is not exercised and the court becomes too reluctant to intervene, it may undermine the effectiveness of both arbitration and the court. Therefore, this court or a high court, as the case may be, while exercising jurisdiction under section 11 of the act, is not expected to act mechanically merely to deliver a purported dispute raised by an applicant at the doors of the chosen arbitrator.
Anything else?
And my lord, the Delhi High Court judgment which I have earlier given, there exactly same issue came up, my lord, the 20% issue.
Huh? Acha. Yes. Where?
Here, my lord, paragraph 12 is the particular clause, my lord, similar to the clause which I have pointed out, my lord.
Yes.
The rights of the party to seek recourse to arbitration are also governed by clause 34 of the SEC, which provides as under. The provisions of clause 63 and 64 of the GCC of the contract will be applicable only for settlement of claims or dispute between the parties for value less than or equal to 20% of the value of the contract. And when the claims or dispute are of value more than 20% of the value of the contract, the provisions of clause 63 and 64 and other relevant clauses of the GCC will not be applicable and arbitration will not be a remedy for settlement of such dispute. Thereafter, my lord, appreciating that, my lord, in paragraph 15, the final conclusion by the court, my
Yes.
lord. Petitioner has not contested that the aggregate value of the claim would exceed 20% of the contract value. Petitioner's only submission in this regard is that arbitral tribunal will determine whether the claims are non-arbitrable. As stated above, the court, even in this limited jurisdiction in the section 11, would conduct a preliminary inquiry to find out if claims are ex facie arbitrable. My lord, so therefore, my lord, the court held that, my lord, that the dispute is not arbitrable. Now, my lord, another judgment of our court, my lord, that is arbitration petition number 28/20.
Yes.
There, my lord, the parties the court has, my lord, in paragraph 13. The court has upheld that clause 20% and the parties have agreed to reduce the claim, my lord.
Reduce the claim.
To make it, to come within the scope of the arbitration, they have.
You will not want to come within below 20%. 20% will come to claim will have to come to around 1 crore.
Less than 1 crore.
Because if the contract value is 5.07, then he has to come within 1 crore. If he comes within 1 crore, then it can go for arbitration.
For arbitration. We are not going to reduce, my lord, because your lordship may kindly see, it is not.
What is your claim? When is your claim made? Let us see the claim.
Now, first of all, your lordship may kindly come to.
First of all, please answer my question.
Yes.
Your claim is at para 14, I think, no?
Para 14.
So your claim is what? 3 crores 25.
Yes.
Huh? Your claim is not 1 crore 86, it's 325.
Yes.
So more than half.
Yes. Now, my lord.
Yes, just a minute. So Mr. H. Gupta, his claim is not 1 crore 86. From where do you get that? You come to page 11 of his petition. And what is the contract value?
Contract value, my lord, 4 crore 30,95,000.
4 crores, 4 crores?
At page number 20. 4
Page-
crore.
Page 20.
Agreement 4 crore 30,95,325.
4 crores 30, 95, 325.
Yes.
So I do not know from where you got your figures.
My lord, this is from the instructions which I have received, my lord.
Instruction, but you come to page 20, this is the agreement. Page 20 is the agreement and page 11 is his claim. he's claiming basically 75% of the contract value.
No, it would be still more than 20%.
No, I said it is more than 75%.
My lord. My lord.
Now, my lord, as per their contention, they may say for up to 20% we can go for arbitration. And beyond that, we can go for civil proceeding. Whether bifurcation of cause of action is permissible, it is not permissible as the Honorable Supreme Court in the case Sundaram Finance versus T. Thankam
No,
in paragraph, my lord, 11. The Supreme Court says the attempt of the trial court and the approach made by the High Court in bifurcating the cause of action is fallacious. It would only lead to delaying and complicating the process.
para,
Para 11.
what is the citation?
Citation, my lord, 2015, volume 14, SCC, page 444. Sundaram Finance versus T. Thankam. Now there is another judgment, my lord, in this respect I am referring.
So bifurcation of claims are not permissible.
Not permissible, my lord. They cannot say for the part of the claim we can go for arbitration and for another part we can go for civil proceeding.
No, we have not stated that to go for civil proceeding. What is provided in the contract is that only 20% of the claim is arbitrable.
No, but then it is also provided in the thing, in the clause that they can go for a civil suit.
No, that is not provided.
That is not provided. Where does it say that? Let us see.
That is not there.
No, let us see. Let us see 10.2.
But it only says that, my lord, claim which is more than 20%, my lord, will not, arbitration will not be a remedy for settlement of such dispute.
Then what is the remedy? They cannot be left remediless.
That is open to them, my lord. We are bound by the contract, my lord, because parties have agreed to the contract agreement.
Now, my lord,
You see, but if there is a dispute, you mean to say they have to be they should be left remediless? How can that be? I don't think.
my lord, another judgment, my lord, I am referring this.
Just a minute. It's only with regard to 63 and 64.
Yes, my lord. My lord, at the beginning, my lord, at 10.0, it is very categorically stated that the arbitration and settlement of dispute shall be governed by clause 63 and 64 of the general conditions of contract, which are reproduced herein below. Reply to the arbitration notice, my lord, we have categorically given this reason.
So, no, they can always go to civil court. I don't think there is any bar.
They can go to civil court, my lord, so far as it is open, it is okay, yes.
No, that is always, there. You
It is
see,
always open, man.
they cannot be left remediless.
Yes, yes.
Now I am referring, my lord, another.
How many cases are you referring to? Don't give me one at a time. How many? Just tell me straight away.
About 6, 7 cases
To what effect?
regarding this invalidity of that,
Okay, sure. Invalidity. Invalidity of?
of the 10.1, clause 10.1.
Yes.
2012. Item 2, volume
Did
2.
you give that list of books to him?
Yes, I will give the list of.
When are you giving? After you read it? After you go off?
No. By Monday I will give.
No. Why we're wasting time?
Today also I can, give.
You have to give now. What?
Because I have not, only one copy is available, some of these.
Then I will also consider that while passing the order. That you have not given.
No, one judgment.
Given us any, huh? Okay, you have not even given him a list of books. Not given, no?
Not given because they have not filed any affidavit, so
So
I
what?
was not aware what type of issue pleading they are raising.
You could have read the last order of this court.
We have replied to their notices, madam.
Have you read the order of this court? Last order? Who told you not to read?
In all the cases, madam, there is a reply to their application on the section level.
May I read, my lord, just one paragraph of
Yes,
One.
what is this? What is the case?
2012, volume 2 SCC,
SCC,
yes,
page,
page 315,
para,
paragraph 17, my lord.
what does it say?
Basically, what section 28 read with section 23 does is to make it very clear that if any mutual agreement is intended to restrict or extinguish the right of a party from enforcing his her right under or in respect of a contract by usual legal proceeding in ordinary tribunal, such an agreement would to that extent be void. In other words, parties cannot contract against each other. So that this clause 10.1 is void in the eye of law because it is restricting to go to the ordinary tribunal.
No, it doesn't bar you to go to.
Arbitration clause, my lord, that clause which.
You see, it doesn't bar you to go to any judicial authority
My
or
lord, they are
judicial
saying that
forum.
my lord,
Arbitration is only an alternative mechanism.
yes,
It is not the main mechanism. There is always civil court. It is only a alternative mechanism. It's only a alternative dispute forum. Please remember that arbitration, mediation, lok adalat, these are only alternatives. It is maybe a faster alternative, better alternative, maybe. But the fact remains that it is an alternative. Alternative means there is something basic already there. So don't say,
yeah.
don't try to give that, that submission of yours is, I don't think, correct. When you say that once arbitration is left out from the scope of, as a means to resolve dispute, nothing remains. It's not that. It is only an alternative. Next.
Next, my lord, 2019 SCC online, SC page 361. I come to
SC 361.
361,
Para?
paragraph, my lord. 14, 15, then 18, 20, 21, 23.
I tell you what you do. You just give me this. I will read it.
Yes,
There's
this time.
no time. We're wasting time otherwise. Yeah, this is not the way to make submissions. Only you have a copy of the citation. You have not given a list of books to him also, so that we can be on the same page. Right. Heard, Mr. A. Ahmed. learned counsel for the petition. Huh?
R Hussain.
R. Hussain, learned counsel for the petition. Also heard Mr. H. Gupta, learned CGC, appearing for all the respondents. The petition, the present application under section 11(6) of the Arbitration and Conciliation Act, 1996 is for a reference of the dispute between the parties before sole arbitrator to be appointed by this court. Full stop. The petitioner's case is that the respondents had floated tender number, full stop, CE, let's take this in paragraph 3. And here. The petitioner was selected to do the contract work, and accordingly, a contract agreement dated 2/3/2007 was executed between the parties at a total cost of rupees 4,30,95,325. The petitioner furnished the initial security deposit. No, don't put that. Then you're right. The time for completion of the contract work was 18 months, that is on or before 21/9/2007. Question. The petitioner's further case is that he successfully completed the contract work on or about 27/3/2012 after being granted various extensions by the respondent. The dispute arose between the parties as settlement and finalization of the final bill of the petitioner was not being made by the respondents. The petitioner thereafter lodged his final claim claim dated 9/5/22, final claim dated 9/5/22, claiming rupees 3,25,79,502. However, the same has not been paid to the petition. Next paragraph. The petitioner's counsel submits that as per the contract agreement dated 2/3/2007, executed between the parties, an arbitration clause for settlement of disputes through arbitration is present by clause number 10 of the 10.0 of the agreement, the relevant clauses being 64(1) and 64(3) Roman 2 small in clause 10.0. Which provides that dispute between the parties regarding the operation of regarding the construction or operation of the contract or the rights and liabilities of the parties should be decided by a arbitral tribunal. The petition counsel submits that though the petitioner has invoked the arbitration clause by issuing notice dated 22/11/22. The respondents have failed to act on the prayer of the petitioner.
We have replied,
No, no,
we have replied.
Acha.
Page 98, madam.
you have replied, but he says failed to act. So where is your reply? Page?
Page number 98. Regard to that 20%, madam, page 100, claim number 6. They disputed the claim only.
Have failed to act on the application made by the petitioner by disputing the claim of the no, comma, while disputing the claim of the petitioner. Pusta. The petitioner has thus approached this court. Pusta. Mr. H. Gupta, learned counsel for the respondents, submits that in terms of clause 10.1. Page
51.
Huh?
Page 51.
Page 51. Clause 10.1. Of the GCC,
No, it's a contract agreement.
of the contract agreement, which has to be read along with clause 10.0, which comma 10.0 that encompasses subclause 63. It will be subclause or what?
This will be subclause, madam.
Subclause 63 and 64. Huh?
63 clause, it is clause of GCC. This GCC clause incorporated.
Which incorporates the GCC, which incorporates clause 63 and 64 of the GCC. Shows that the provisions of clause 63 and 64 of the GCC would be applicable only for settlement of claims or disputes between the parties for a value less than or equal to 20% of the contract value. So the claims beyond 20% of the contract value would not attract clause 63 and 64 of the GCC. He accordingly submits that the petitioner's application should be dismissed and should be dismissed. Asha, one thing now for the petitioner, For the petitioner, we just say the petitioner's counsel submit that clause 10.1 of the contract agreement is a void clause And in support of his submission. No, no, full stop, in the white clause, full stop, he submits that in terms of subsection 6 bracket, no, subsection, no, 6 capital A, 6 capital A of section 11 of the 1996 Act provides that the Supreme Court or the High Court, while considering any application under section 11(6) of the 1996 Act, would have to confine its examination with regard to whether an arbitrator is to be appointed, comma, only by considering whether an arbitration clause existed in the contract agreement. He submits that the issue whether the arbitrator could decide, could decide the claims made by the petitioner in terms of clause 10.1 of the contract agreement would have to be decided by the arbitrator so appointed by the court, arbitrator, comma, so appointed by the court, comma, in terms of section 16 of the 1996 Act.
Including, my lord, the validity and invalidity of clause 10.1. That is important.
Okay, including the validity of clause 10.1 of the contract agreement. Full stop. In this regard, he has relied upon the Constitution bench judgment of the Supreme Court in the case of interplay between arbitration agreements under the Arbitration and Conciliation Act, 1996 and the Indian Stamp Act, 1899. Full stop. This Globe India is by you. This is your case, Mr. Gupta. Globe India.
Yes, ma'am. The Supreme Court judgment, my lord, paragraph 27.
Are you relying upon the Guwahati High Court order, which is judgment which you have produced, which is against you? This is against you. The one that you have mistakenly given to me.
My
I
lord,
think.
the Honorable Supreme Court left open this point, my lord.
Mr. Counsel, this is the judgment that you have given to me, but this is unfortunately against you and in support of him. Are you relying upon this or you don't want to rely?
I don't take it.
So by mistake, you have handed it over to me. He didn't know about it. Neither did I. Happens sometimes. Okay, then, okay, then who has given me this Lombardi Engineering? You have given?
Yes.
Which paragraph are you relying upon here?
I'm parting. Paragraph 24.
In Lombardy.
Yes, my lord. 26. and 27.
Don't give me everything. Just give me the
Very
operative portion.
important judgment, my lord.
Maybe, but then you've got to hit the point. Don't go around the bush.
Because there are three issues were decided by the Honorable Supreme Court. Just I am pointing out that. Paragraph 24, my lord.
Yes.
Having heard the learned counsel appearing for the parties and having gone through the materials on record, the following issue falls for consideration of this court. Whether the dictum as laid down in ICOM Tele Limited can be made applicable to the case in hand, more particularly when clause 55 of general condition of contract provides for a pre-deposit of 7% of the total claim for the purpose of invoking the arbitration clause. Whether there is any direct conflict between the decision of this court in SK Jain versus ICOM Tele Limited. Whether this court, while deciding a petition filed under section 11(6) of the Act 1996 for appointment of a sole arbitrator, can hold that the condition of a pre-deposit stipulated in the arbitration clause as provided in the contract is violative of Article 14 of the Constitution of India, being manifestly arbitrary. Whether the arbitration
This has
clause-
got nothing to do with it.
Yes.
Then, this SK Engineering, anyone? Not Reliance. Okay, that's all. I think that's one judgment, that's all. The other judgment is not in your favor. Okay, right. Here, the petitioner's counsel accordingly submits that that this court should appoint an arbitrator in terms of section 11(6) of the arbitration, of the 1996 Act. Full stop. On the other hand, next para, Mr. H. Gupta, the learned, have I said all that? Already said that. So, okay, that is, I mean, then in H. Gupta, it said, Mr. H. Gupta, on the other hand, no, Mr. H. Gupta has relied upon the judgment of the Supreme Court in the case of NTPC Limited versus SPML Infra Limited, reported in 2023 9 SEC 385, the Delhi High Court judgment in the case of ARB full stop P full stop 933/2022 and IA 5219/2023 MS BCC dash Mona Lisa LISHA bracket JV versus Container Corporation of India Limited, and the decision of this court in the case of, and the judgment and order dated 26/10/2021 passed in Globe India Enterprise versus Union of India and others. ARB full stop P full stop 28/2020. Full stop. Next. Okay. I have heard the learned counsel for the parties. Clause 10.0. And 10.1 of the contract agreement states as follows. Now, that is page 48 is 10.00. This small. And this is at page 51. Okay. There's another order. There's another order. Justice Koteshwar Singh's order, I think. This Koteshwar. Ah. Next, right? Clause 63. And 64. Of the general conditions of contract, bracket GCC, has also, which provides for the re- which provides for resolution of disputes through an arbitrator, through an arbitral tribunal, is also a part of the general conditions of contract. No, is also a part of the contract agreement executed between the parties. Question. The next para, the provisions of clause 63 and 64 of the GCC clearly provide for disposal of, no, for resolution of a dispute through arbitration. And as such, in terms of clause 10 of the contract agreement made between the parties, comma, which incorporates clause 63 and 64 of the GCC, comma, the dispute raised by the petitioner would have to be decided through an arbitration process. However, clause 10.1 of the contract agreement puts a rider in respect of the application of clause 63 and 64 of the GCC, comma, wherein it provides that where the dispute with regard to claims less than or equal to 20% of the value of the contract work would attract clause 63 and 64 of the GCC. On the other hand, when the claim are of a value more than 20% of the value of the contract work, comma, the provisions of clause 63 and 64 of the GCC would not be attracted. The petitioner hearing, the petitioner has made a claim for rupees 3,25,79,502. And the entire contract work and the total contract work as per the contract agreement is 4,30,95,325. The claim made by the petitioner against the respondent is thus approximately 75% of the contract value. Next para. On a plain reading of the on a plain reading of clause 10.0 and 10.1 of the contract agreement, it is clear that clause 63 and 64 of the GCC are not attractive. To the case in hand. No, to the case in hand. For appointment of an arbitrator. So, sir, the issue that would have to be this, no, the above being said, comma, the petitioner has stated that clause 10.2 of the contract agreement is void. So, sir, at the outset, it may be noticed that there is no challenge made to 10.2, clause 10.2 of the contract agreement by the petition. So, sir, in the case of that will correct. Okay, basically, I'll have to now put on all your judgments. Otherwise, you all will say no one has. The thing has not been considered. So these judgments I will. So just say hearing concluded, judgment reserved. Everything. Well, I need some notes. There are two repetitions.
To arbitration.
Same issue. Okay, in the other, what is the amount?
The amount 34, the amount is different.
Amount claimed is at amount claimed will be at para 14 again. Amount claimed is you were speaking of the other case. Mr. H. Gupta, I think. 186.23.336.78 and as per the contract agreement 507. Okay. So that is also above.
Around 36.68%.
36.6. Okay, anyway, we see. So yes, data, we do this. Right now I give you dictation on 36. So you do that, we'll see. So hearing concluded, judgment reserved both, huh? No. Huh? Yes, yes, continue, Dinesh.
25 is also same, same issue.
Whose matter is this? Okay, same concept.
Same,
Okay, same. Hearing concluded, judgment reserved.
same issue.
Figures will change. I'll do one only then.
In all the
Everything
cases, model, we have replied to the notices in the section 11, wherein we have raised this objection.
In all the three
All the
cases.
three.
Anyway, whether you raise it or not, we're deciding that issue here on. Other than that.
26, my lord, I have.
Here, just one.
Yes.
My lord, here, one thing is there. In other cases, your lordship has observed, I have not challenged the clause 10.1. Here I have in paragraph 26, my lord, in this case.
What have you said? What have you said?
Lord, if 10.1 is challenge, entire clause goes, my lord, arbitration clause. That is the arbitration clause, my lord.
No. 10, if he has challenged 10. If he challenges
That is
10.1,
part of
does
the-
not.
That 10.1 is part of the entire 63 and 64.
63 and 64 is the GCC which has been put into 10.
Yes, 10.
So he has to challenge 10.1. 10.1 is the one which is blocking him.
Yes. So never challenge independency.
I don't think it's there, Mr. Counsel. You would have found it in a flash.
In the first, I mentioned there is no pecuniary limitation in other case, 26.
That doesn't mean that you have challenged it.
Yes.
Now it is come under section.
Under section 11, my lord, this is not the forum to challenge the agreement,
Correct.
my lord.
Correct.
Can be, my
Then
lord.
you could have challenged it separately.
The Supreme Court judgment which I have relied, my lord, the arbitrability can be looked into at the pre-referral stage, my lord, by 2023
No, arbitrability, that's what we're looking into.
My lord, to look into that, my lord, interpretation is not.
Of course, but that arbitrability has to be looked into, you know, like it should be very apparent.
Apparent, my lord.
It should be very apparent,
Yes, my
that's
lord.
all.
And while Leonard Pandit is asking for interpretation.
He
That
can ask
cannot
for
be.
anything, you can ask for anything, he can ask for anything.
Now, as per subsection
be
6A,
interpreted.
only court has to look whether arbitration agreement is there or not.
According to
More
you,
than, not less than.
correct, correct. No, that is one way of looking at things.
Yes. Because arbitration clause is 10, not 10.1.
Arbitration is 10. But then 10.1 is there also.
There.
How can you've got to read all the clauses together.
There. No, my lord. Because so many clauses are there. in
No,
the
it says
agreement.
subject to, that word is there, subject to.
So many clauses in the agreement is there. I will challenge
You-
before the arbitrator also. This is related to merit of the case. And because as per subsection 6A, it is beyond the jurisdiction under section 11.
Unfortunately, you have given me an order passed by this court.
Our court judgments are there.
They challenge and that was dismissed. my lord.
No, they have reduced the claim. They've agreed to reduce the claim to go before the arbitration.
No, that is a different issue.
The clause was up.
That, yes. No, it's okay, we're finished. We're wasting time, others are waiting.
Ultimately.
In item 26,
Yes.
that I have instructions that there are some further developments in the matter. We are praying for 2 weeks' time to file a additional affidavit. I've informed my learned friend also.
It's there, but my lord, the pleadings otherwise are complete.
Otherwise, pleadings are complete. There are some subsequent developments which we need to bring on record. So
So you're not objecting or are you objecting or what? Make up your mind.
But the short adjournment may be given, my lord,
we are just praying for 2 weeks.
Okay, Mr. I. Chaudhary, Leonard, the senior counsel for the petitioners is granted 2 weeks time to file
An additional affidavit.
additional affidavit. That's all?
Can
Can it be on 13th?
No.
On
This-
13th of March,
no,
interim has to.
This is the matter on 13th. Interim order passed shall continue till the next date.
Obliged.
28.
Our presence may be recorded, Lordship.
Acha, Mr. R.K. Talukdar appears for?
Lordship, I should have.
Oh,
Already
Mr.
responded. Already responded.
You record the evidence. You record the presence, huh?
I'm assisting.
Assisted by, so, huh? Assisted by R.K. Talukdar.
Lordship, in item number 28, the matter pertains to non-payment of.
You got it, no? You got the senior counsel's name, no? PPS IKEA. Yes, item?
Lordship, item 28, Lordship, it pertains to non-payment of the
Bills.
bills of the petitioner, Lordship. Lordship, we directed to.
Verified pay. The amount has to be admitted by the highest authority, that is the chief engineer.
Correct.
In this case, it has been admitted by the executive engineer. So the chief engineer will verify and pay.
Lordship, a time frame may be fixed, because they have otherwise admitted. Your Lordship will find it at page 25. It is prepared by the accounts officer as well as the executive engineer.
No, this is not the
Or if
admission.
they want to-
Mr. D. Gogoi, learned counsel for the PhD department submits that he has not received instruction. Okay.
Lordship.
Whether the vehicle repair bills are admitted or not.
Lordship will
Yes.
fix the time frame and ask
It
them
has
to
been
verify
admitted
again
by
and
the
we
executive
make the
engineer.
payments accordingly.
The amount has to be admitted by the chief engineer.
The problem is, as per Tamsher Ali, it has to be admitted by the chief engineer.
Lordship.
Lordship, let them verify the bills. Lordship may fix the time frame and
Verify and pay.
because it's a garage work, Lordship. Doesn't.
How much is the amount?
Lordship, 4,11,100.
See, but one thing is that there's the problem. Once we admit one, then whole verification. And what we have heard is this verification business has now become a big source of corruption.
Otherwise, let them file an affidavit to the effect, Lordship.
You just clarify whether it's an admitted amount or not. That way it becomes easier for this court. Otherwise, you see, once we pass an order that it should be verified,
Lordship.
then it becomes a problem for the department also.
Some time may be given, then your
So that becomes clear. Otherwise, we become the source of corruption also in it.
And finance has not been made a party here, which is a necessary part.
It is the work of the PHA lordship. These are matters pertaining to the repair of their vehicle.
Ah.
The work order issued by them. Finance is not necessary part in it.
Miss
And Kalita, your lordship.
M. Kalita appearing for the PhD department
Yes, your lordship.
is granted
Next time, your lordship.
2 weeks time to obtain instructions and file affidavit, if required. Full
Lordship
stop.
may,
She shall, on the next date, inform this court as to whether the unpaid vehicle repair bills are admitted or not by the respondent.
possibly annexure 4, she may take instruction on that. Annexure 4 at page 25.
How much is the amount?
4 lakhs 11,153.
Specifically annexure
Annexure
Four.
4, page 25. Okay.
4, huh?
Lordship is fixing a date, Lordship.
Noted. This is the matter after 2 weeks.
Lordship.
Obliged to.
Huh? What book list? No, no. What? Oh, that, okay. With the paragraph. Yes, any objection to the implement?
Yes, she is.
Okay, then you make a submission.
Yes.
No, no, not you. Oh, I want to hear it.
Highlight in the. Just short, the petition was filed against the blacklisting order.
Hmm.
Now, a prayer was made for a stay of the blacklisting order. Now, since the BPCL council was not there, no interim orders were passed, and it was said that after service of notice,
BBCL means?
with the responding corporation,
Huh?
responding corporation.
Corporation.
Corporation. But certain tenders were already filed by the petitioner in other tenders. And certain tenders last date was there. So all of the tenders which a petitioner filed would have been rejected because of the blacklisting order. And the petitioner would not have been able to participate in the
Correct.
subsequent order. So the petitioner filed a writ appeal for some protection, and some protection was granted, blacklisting order was not stayed. Now, when the matter again came up before this court, on 5/1/2024, University of Kalisi,
5/1/2024.
after the division bench order,
10/1.
5/1,
Huh?
In the petition, you also see,
Page 30 of that.
page 30 of the IE,
Page 30. Yes.
in the last portion,
Yes.
last 5 lines below. This quote further. And you got to do that.
Page
And the
33.
this is, it will be 30, 31, 32, 33, the last part of the order, 33.
Yes.
Last 5 lines below.
Yes.
This court further makes it clear. And you also got it, This court further makes it clear that so far as the works which the petitioner has submitted with, which are subject matter of the observations of the engineers, the authorities may go ahead with the tender process and finalize the same. But before allotting the work, leave is required taken from the court. The tender process was not stayed by this honorable court. The court said that you finalize the tender process. Only leave was to be taken by the responding corporation from this honorable court before allotment of the work. Now, no such leave application was filed that by the responding corporation on the ground that the tender process has been finalized and the leave should be granted.
So to say that this order had stayed the tender process in all of the tender process is not correct.
Correct.
Now, the tender in issue in the writ petition and the tender which my learned friend is saying applicant are altogether different tenders, which you'll also find in the impediment petition itself. You'll also find. You'll also see para 26 at page 16.
Yes.
That the writ petitioner had participated in tender number so-and-so dated so-and-so. The writ petitioner did not seek any relief in the said writ petition in respect of tender number so-and-so dated so-and-so, though it was disqualified from the zone of consideration by virtue of the blacklisting order. Now, this tender, the contention of my learned friend there, the tender, another tender which was there, which was not the subject matter of the writ petition, but the petitioner got disqualified because of the blacklisting order, that tender. And in that tender, the contention is that the petitioner is L1 and the applicant is L2. So
No, anyway, no, he has participated in which tender?
my lord, some other tender, my lord, not
Not in,
not in this.
no,
tender.
right now.
My lord,
What is the tender that you have participated in?
Well, the tender which the flow was floated by the respondent number 2, that was the subject matter which was.
Mr. Counsel, please, it's a simple question.
The-
What is the tender that you have participated in right now?
This is 23, my lord.
Huh?
23.
my lord, if you look, it will be a para 30.
Para 33.
Para 30.
33.
That is different.
Now, para 30, you'll also see, my lord.
That the petitioner hearing, you are the petitioner.
Yes,
No,
I'm applicant of this.
Para 30, you'll
Okay,
also see,
that
my
the
lord.
petitioner hearing.
Petition is I applicant, it should be applicant.
This is applicant, that's what.
Yes,
This word should be applicant.
yes.
The word should be
So,
applicant.
Applicant is
Applicant.
L1.
That's what.
Let's all
That's why he has come.
Yeah.
Applicant is L1 in tender note this one.
some other tender, my lord. No,
Okay.
he's not an L1. L1, I am an L1.
In which,
In another tender, my
no,
lord.
no, I'm talking about this tender.
My lord,
now
this
thi-
tender, he's not there.
He's not there.
But you also see para 30.
Yes,
That the tender number so-and-so was not part of the proceedings of the WPC number so-and-so.
no, that is not the issue. That is not the issue.
But the
Wait,
writ petition,
aside for 2 1, yes.
but the writ
That
petition
the tender was not a part of the proceedings
of
of.
the WPC number so-and-so, though the said tender was alive and under consideration when the writ petition was filed. Well, he's speaking of some other tender.
Yes. Yes, my lord.
Well, the tender which was in issue, well, subject to meaning, the tender which was in issue in the writ petition because of which the blacklisting order was passed. That is not the issue. That is not there.
No, just in this page, this para 33,
Milo.
did you participate in this tender?
No, 30 I participated, 33 I participated.
Participate. Did you participate in this
Yes,
tender?
yes.
That's
No, I
enough.
was, just, a minute.
Yes.
I was found to be L1 and he is L2.
Ah.
In that tender process.
No, I'm not on that. I'm on this, only on this, para 30 and 33.
Well, para 30 and 33, well, just I say, well, his contention, applicant's contention is
Yes.
that because of the interim order passed,
Ah,
though the writ petition is not subject to anything, subject matter of the writ petition is not connected at all.
correct.
Because,
But because of the stay, because of the order, interim order pass.
because of the interim order passed, he is affected.
Correct.
Now, the question which is there, my lord, you're asking first, when is the interim order?
No, I get it. Your case is that as per the interim order, the corporation can come anytime and take the permission of the court.
Had not stayed the tender process. This honorable court had you finalize the tender process. And once you finalize the tender process before allotment of the work, you take the leave of the court. Now, if the respondent corporation has finalized, they are not saying that finalized. If they are finalized, nothing stop the respondent corporation from coming to the court
Correct,
to seek the leave of the court.
correct,
Now, the respondent corporation has not come before the court, they are
Correct.
seeking leave of the court.
correct.
Now, only thing that, my lord, I want to place few judgments, my lord, that in what stage, whether he has got a legal right to be implicated in party. I can understand, my lord, that his interest is affected. Because somebody's interest is affected.
No, yes, I get it. So basically, he doesn't have, just because, so your case is just because he has got an interest, doesn't mean that he has got a legal. That is your case.
I'm grateful to your lordship, my lord, but to my satisfaction, my lord, if your lordship permit me, I will place few judgments, my lord.
This is.
A copy of the. In fact, this matter come up before division bench of this noble court also. And there also, my lord, there's the same law was followed. I am just placing, my lord. Lordship, see page 1 first and the relevant part at page 4.
Page 1, yes,
Page 4, my lord.
page 4.
At the
Yes.
bottom, my lord, at the
Yes.
bottom,
Yes,
the proposition that a plaintiff cannot be incomplete to join the proceedings to whom he wish to sue against which he does not seek relief is exemplified in so and so. These cases also indicate that the applicants cannot succeed in their interest is only indirect. Now we'll also skip over, come to page 6, my lord.
yeah. It's. Yes,
At the bottom, my lord, 8 or 10 lines.
Yes.
It seems to me
yes,
that it is the more important to constitute this rule strictly because it is the right. The provisions might be made use of the manner exceeding harassing the plaintiff by forcing them to include in their actions persons against whom they do not seek to proceed and mix up their rights as against the person with sessions of highly complicated nature existing orienting between themselves and the others. So and so, I am quite clear, however, that the courts ought not to bring any person as defendant against whom the plaintiff does not desire to proceed unless a very strong case is made out, showing that the particular case justice cannot be done without his being brought in. Lordship may thereafter skip over and the middle, my lord, of the next paragraph. The plaintiff is not bound to, my lord. As you lordship.
yes,
My lord, the plaintiff is not bound to issue both the trustees. The lordship then consider the wordings of the rule and a number of authorities and proceeded. Looking at the rule, you must order to say that a person who is not a party ought to be added. Find either that ought to have been added or that his presence before the court may be necessary in order to enable the court to effectually and completely to adjudicate and settle all the issue questions involved in the case matter. I cannot hold that the plaintiff sought to have joined so and so a defendant and his presence is not necessary to enable the so and so. The lordship may skip over and come to Miller page 9. Miller. At the bottom below.
there is no pagination.
Well, page in the top, I think it is 9. And
Page 9, yes,
my lord. At the bottom, my lord, Lindsley LG,
yes,
my lord. Having referred so and so, in order properly to understand the rule, but must look at the all of it. It begins by saying no cause or matter shall be defeated by reason of the misjoinder or non-joinder of the party. That is the key or to the which whole section. If the court cannot decide the question without the presence of the other parties, the case, the court is not to be defeated. So, my lord, if the court cannot decide the issue without the presence of the party, one party, then, my lord, a person may be added. Page 10, my lord. The fifth line. It is true. Had you also got it?
Yes.
It is true that his interest may be affected commercially by a judgment against the defendant, but can it be said that it would be legally affected? Can we state the rule so far as to say that whenever a person incidentally affected by judgment, he may be added a party into defendant? And conclusion was that, my lord, that no. Thereafter, Lordship may see, my lord, page 14. And I will take you, Lordship, to page 26, my lord.
Not page 14.
Page 14 it starts, my lord, and the 11th part at page 26, my lord. Second judgment, my lord.
Yes.
26, my lord. Just the last paragraph. If
26.
26, my lord, the running page, my lord, you'll also find the top.
Yes.
If this is the line of authority that is correct, one can apply, then I must check. The test is, may the order for which the plaintiff is asking directly affect the intervener in the enjoyment of his legal right. It is not only view enough that the plaintiff's rights and the rights which the intervener wishes to assert should be connected with the same subject matter, nor it is enough that the intervener's commercial interest may be affected by an order made in the action. The distinction between legal and commercial interest appears to be sharply drawn in the decision of the Court of Appeal, so and so. So the distinction was made, my lord, between the commercial interest and the legal interest. This has also been subsequently followed, my lord. My lord, you'll also see page 32, my lord.
Yes.
At the bottom,
Yes.
third line. If the court cannot decide the question without the presence of the parties, the cause is not to be defeated, but the parties are to be added so as to put the proper parties for the vote. Now, question which I am posing to myself, my lord, whether the writ petition, the cause of action of the issues which are involved in the writ petition, whether they cannot be decided without the presence of the other party, the applicant. Now, you'll also kindly see, my lord, page 34. The second paragraph, my lord, the fifth or sixth line. The person to be joined. Page 34, my lord.
Which line?
The fifth or sixth line, lord, the person to be joined.
From the top.
From the second paragraph, my lord. Of course,
Yes, the person to be joined.
the person to be joined. The person to be joined must be someone whose presence is necessary as a party. What makes a person necessary party? It is not, of course, merely that he has relevant evidence to give on some of the questions involved that would make him a necessary party. It is not merely that he has an interest in the correct solution of some questions involved and has thought of relevant arguments to advance, and it is afraid that existing parties may not be adversely be adequately. That would mean that on the construction of the clause in the common from the contract, many parties would claim to be heard, and if they were power to admit any, that is no multiplicity of the discussion in which some would be admitted and others refused. The court might offense, and thereafter, my lord, I will take it also directly to the Supreme Court decision also. Other two decisions are on the same issue, my lord. So I'm not troubling your lordship. My lord, one judgment, my lord, I may place page 48. It starts.
How many judgments are you giving me? I'll, that's not an issue. I can, you just give me the thing, I'll read it.
Well, I will,
I don't have to read everything.
well, I will place before you also the Supreme Court decision one,
Yes,
that will be, Lord,
because
place
we don't
71.
have time.
Well, I understand, Lord, there are motions matters and other matters are also.
Yes, yes.
Well,
Plus, this is only a,
My lord, I fully appreciate it.
Yes.
Page 71,
yes,
and you'll also see page 77.
yes,
Para 12, my lord.
yes.
If you'll also permit me, these 2-3 paragraphs I may read, my lord. Sinha just speaking for the majority said that a declaratory judgment in respect of disputed status will be binding not only for the parties actually before the court, but also the persons claiming through them respectively. This court laid down the law that a suit relating to property in order to, in this paragraph, we have speaking, my lord, you'll also come directly to paragraph 14. At page 78.
Yes,
It cannot be said that the main object of the rule is to prevent multiplicity of the actions, though it may incidentally have the effect, but that appears to be desirable consequence of the rule rather than to the main objective. The person to be joined must be one whose presence is necessary as a party. What makes a person necessary is not merely that he has relevant evidence to give on some questions involved. That would not make a necessary party. It is not merely that he has an interest in the correct solution to the questions involved, and that thought of relevant argument to advance. The only reason which makes it necessary to make a person a party to an action is so that he should be bound to be result of the action and question to be settled. Therefore, must be a question in the action which cannot be effectually and completely settled unless he is a party. The line has been drawn on a wider construction of the rule between direct interest and the legal interest and the commercial interest. It is therefore necessary that the person must be directly and legally interested in the action on the answer, and he can say that the so-and-so is a party. Well, one more judgment of the Supreme Court, Lord. Well, at page 58, it starts. And at page 69.
yes,
Para 16, my lord. 7 or 8 lines from the top, my lord.
yes,
The eventual interest. As you also got, my lord. The eventual interest of a party.
yes,
The eventual interest of a party in the fruits of the litigation cannot be held to the true test of impairing parties under the Code of Civil Procedure. Now, the division bench judgment, my lord, you'll also can see at page 81. The relevant part at page 90, my lord.
yes.
From the above extracts, it is clear that the Supreme Court has taken an affirmative view that a stranger cannot be permitted to meddle in any judicial proceedings unless the court is satisfied.
Page 91.
Page 90, my lord. I'm sorry.
Yes,
From the above extracts, it is clear that the Honorable Supreme Court has taken an affirmative view that a stranger cannot be permitted to meddle in any judicial proceeding unless the court is satisfied that such persons fall within the category of the aggrieved person who has suffered legal injury and is entitled to challenge the effect action of the order of court of law. It was further observed that the court can enforce the performance of
this is with regard to writ petition.
Well,
This is with regard to writ petition, whether a person can file a writ of mandamus.
that was in the case of intervener. The intervener went to the for filing the appeal,
Okay,
and the court said that no, we will not permit you because your commercial interest is all affected, not the
No.
legal right.
this is under 226, this issue.
Well, 226 petition, my lord, he filed an appeal seeking leave of the court that he is affected. And the court said that no, your commercial interest may be affected, but not the, my lord, the legal consent. Now, one, my lord, the grievance is against the interim order by which the order is passed. Well, one of the judgment only, my lord, I will not trouble your single board. that the only option open to him, if he can do it, 36 years, to come 1547. Well, I'll do the paragraph numbers for the conveyance of lawsuit separately.
Same judgment.
So this another one.
How many judgments are you giving me? This is not, this is only the implement application.
But the way it was submitted for lawsuit, the lawsuit pays.
Beside which offense?
Which one are you?
It's copy the data.
Yeah, but that's report on the site.
What is the chancery division? Where is the case?
Well, the judgment starts and your lawsuit running pays 465, the internal pays 465.
What is the name of this case?
So name of the case is given below.
Huh?
X party so and so in re so and so.
Page?
Below page 465.
Yes.
Just in the middle below, it is said that.
Yes. Yes.
It is said that any person aggrieved by an order of this court is entitled to appeal. But the words person aggrieved do not really mean that a person who is disappointed of a belief, he may also receive some order and had been made. A person aggrieved must be a man who has suffered a legal grievance, a man against whom the decision has been pronounced, which has been wrongfully deprived him of something or roughly refused him of something. That's why in the last email I submitted, that if any grievance was there against the order passed by the single judge, that will not make a person to be a party to the proceedings. Because, and the learned single judge also had not granted any stay. It cannot be said that the entire tender process has been stayed. Once the tender process has not been stayed, the learned single judge has you finalize the tender. Then to say that my rights are affected, in my humble submission, because in the appeal itself, they are saying in the application itself, they are only saying that because of the interim order passed by this honorable court, they are affected. So my humble submission is going also that cannot be a ground for imprisonment of the parties, and the applicants have not made out any case for imprisonment of the parties. They may be made out in some other tender. They may be L2. Their only interest is that L1, I am L1, so I should be out.
No, they are L1. That's what
I
they
am
say.
L1, Milord. They are L2.
I am L1. I am evaluated. Petitioner means in that application, I am the petitioner. And not only that.
Okay, no, just
I think not only that, the other also.
Milord, so far as Milord, whatever he has.
I think I've heard half an hour of the.
Milord, nothing.
So basically that's the case. Yes.
Yes.
Now let me hear you.
Yes.
Yeah.
But
Please don't take time.
yes, I'll be very short.
Just give me a citation.
Yes, I have also prepared one.
So basically your case is that you are L1. You are L1 and because of the order, the corporation is not finalizing the tender. That is your case.
May I formulate just in 2 minutes?
Okay.
My formulate my entire subject matter.
Yes,
What
yes,
I am,
yes.
why I am here. This is implement of this in the writ petition, in which with the dispute in the writ petition, I have no concern. I am
Yes,
saying
you're not.
no concern with this. But the order which are passed, with that
Has prejudiced you.
I am being affected.
Yes.
And so I have filed an application for intervention, which are in the nature of pro-interest issue, which I will just bring it to your lordship, which the Indian Court, Supreme Court, High Court, all have applied, that if right of or interest of any person is suffered because of an order passed by the court, he can come before the court and intervene in the proceeding. And that here what happened was this. But within 3 minutes I will complete my introduction of that.
You have now gone from 2 to 3. By the end, you'll take 5.
No, but what happened was this writ petitioner was blacklisted by a.
I've got that. I've got that.
Mumbai, Madam. Nothing is that. In a tender process which took place in Mumbai, and no cause of action has arisen within here. Well, players to supply, order, etc., all there. When the order passed, it says it will not be finalized. Which tender not finalized? All outside Mumbai, Hyderabad, Bangalore, and all at different places and different companies. A chart was given to the court where name of the 5 companies are mentioned by making Union of India as a party, and all say everybody from Madras, Bombay have to come here and say leave may be granted to place order because he has brought the petition in a court which has no jurisdiction. Not at all. But 226 subsection 2 confers jurisdiction when a part cause of action or substantial part of
Correct.
cause of action. There is no whisper in the writ petition that this honorable court has this cause of action has occurred or arisen within the jurisdiction of this court. Supply is at Mumbai, payments were Mumbai, blacklisting Mumbai, SOGOs from Mumbai, order passed Mumbai, everything Mumbai, everything Mumbai. And what state? The order affects all parties and everybody all over the India except Guwahati. No Guwahati company is involved in placement of the orders. My Malodi, can you see respondent? There is no respondent within Guwahati. All are outside. Malodi, can you see the cost title? Cost title. Union of India is this. Delhi with
Where is the
well, the cost title of the writ petition, Malodi, can you see? The rest,
Or even
Yes.
even in the IA, Malodi can see this. Cost title.
Yeah.
But in IA also, I have set out this at page.
Petitioners are from Guwahati.
Writ petitioners are from Guwahati and no respondent, no cause of action at Guwahati. Supply.
also supplied from what?
Even petitioner is also throughout India. He is supplying at all places at every country. He has chosen Guwahati High Court for the purpose of staying the all tender proceeding all over India. Whereas in Guwahati, no cause of action has arisen. This order is a nullity. Why I have come? Now, entire process have frozen everywhere. And when it has frozen, either all government companies has to come up.
Look, let us be very clear. This is only an application for impleadment. Please don't go into the merit.
Well, what I'm saying, my application is for impleadment as well as for stay. I'm saying this one. I
Unless-
will satisfy or see.
You see, Mr. You're trying to take a shortcut.
I will-
First of all, this is an application has to be only solely for impleadment.
Yes,
You cannot, you see, unless the impleadment is allowed, there's no question of you making a prayer with something else. Okay, you have to first implead yourself, then you have got the locus to make further submissions with regard to the merit of the case or whatever.
Not here, I
You cannot
I
add
bow
both.
down to Lordship. Milord, the legal jurisprudence on the pro-interest issue is little different, Milord.
So please show me that.
Yeah, yes, Milord. Kindly.
Don't go into, don't waste time. That's what I'm saying.
Judge, my copy I've got this one, no?
Is it this the one?
My lord, I
Ah,
will not
yes, yes,
interfere.
my-
I will not interfere. My learned friend tried to convince you also that he's a L1.
Ah.
Let me find an affidavit. Sport affidavit, my lord.
That
he-
is the-
that is, he's L1. He's saying that if I am blacklisted, he becomes L1. Let him find an affidavit.
No, he says he's L1 with you blacklisted.
Find an affidavit that he's L1.
Let me proceed with the matter.
Let him file an affidavit.
No,
Let me hear.
No, I'm just saying. that-
Otherwise, we'll implead him then. We'll implead him, let him file affidavit.
No, by making a submission for also that he's L1. When he's not L1, he says that if I am blacklisted, then he becomes L1.
As
He's
he
not
said.
L1. Responding corporation, they lost him and verify from him.
And the tenders have been opened or not?
Tender has been opened, evaluated.
And
in the
who is
evaluation,
L1?
I am L1.
Oh, he's L2. Okay,
If I go, then he becomes L1.
okay.
He will remain L2.
Uh-huh. So basically, the issue is with regard to, so then the basic issue is between you two. So then he has got nothing to say.
And the honorable was granted additional relief to the petitioner.
Huh?
I would quote my
Not interim protection.
No, whatever, what has been done. Okay, we cannot go into that issue. Otherwise, that you want to challenge, you can go. That has been done.
L1 and L2 matrix should be finalized, that should be concept complete.
No, so now now, so, yes, so then what is your case then?
My lord, yes. If my lord kindly come to this page 8 of this compilation, my lord, page 8, of which I have given to your lordship, my lord.
Look, you cannot jump into their
No,
problem.
no, what, I am not jumping into that problem, my lord. There are, if my lord kindly see the sweep of the order is like this.
No,
In the
I
chart-
read.
No, this is the chart, which is enclosed with the appeal petition and of the filed by the respondent. And in the sweep, my lord, just see this.
This is the, what is this?
No, this is the chart annexed to the appeal petition filed by them, writ petition.
Appeal petition?
In connection
Writ
with the
appeal.
appeal filed here from the single bench to the
Okay,
single
okay,
bench,
okay, huh.
where they have given the tenders in which they have been affected, and by the sweep of the order, everything has been stated. Union of India is a party. Will you kindly see list of submitted tenders, MPP, department's name, Sabarmati Gas Limited, Indraprastha Gas Limited, GAIL Gas Limited, Bharat Petroleum, Hindustan Petroleum Limited.
Whichever tender is-
All this and respondent number 2, these are not parties, but they are part of the SHAR. They are not parties, but they are affected. And
But then this is not a
I-
PIL.
no, this is not a PIL. This is exactly not the PIL. But the order which has been passed have a sweep, which affects that where he has applied for tender
All over India.
they have to come here for the purpose of final processing. Why not we say that he is L1 or L2? I'm saying this, that this was a completely different subject matter, different tender, different subject matter, altogether different. Whether if he said I am L1, I said L.
Supposing,
Suppose I am L1, L2, L1, whatever. And I'm evaluated. I'm evaluated L1 by I'm evaluated L1, etc. Where I'm evaluated at Mumbai. He has been outclassed, and I'm evaluated as L1. He was L1, but he was blacklisted because of some indecent or dishonest practice conducted by him, which I will submit, my lord. He was rightly blacklisted at Mumbai.
no, that we're not going into that. That is not an issue here.
So that is fully.
Look,
that is- yes,
please, don't get carried away.
yeah,
The issue is basically why should you be implemented?
yes. Well,
Your case is, according to what I can gather, since he's been blacklisted, you become L1,
yes, my lord.
and accordingly you should be given the supply order.
No, I should be by my non-consideration of my case. I am not saying priority. I am saying non-consideration of my case. No, entire place order.
So basically, yes, as per the order of the coordinate bench for that stay order, that does not bar you from finalizing the tender process. Why are you not finalizing?
That could be say.
Well, that order is, well, in fact, we are coming to say that order is without jurisdiction. Because
I cannot, am I an appellate court?
no,
That-
when the matter comes up, your lordship looks into the matter that whether in a.
Mr. Counsel, that issue will come only after you are implemented.
Well, that is.
You cannot mix up the issues. Yes,
Page 29.
of the,
Particular order, madam, page 29 of the. No, people, single bench. I want to 124. Yes. The particular order, madam, page 29.
page 29 of the IA,
Yes, madam. That was only up to 5 million. So after your lordship, she 1 million.
page 29.
The game of the practicing order was not stated, but what is the observation of the divisional bench?
Yes, yes.
Will be, we find
Yes.
that prior interim will be considered on 5/1/24 in view of the matter which has been put up that the briefs of the petitioner firm will not be rejected on the basis of the order that so, but the petitioner firm may also be permitted to furnish space bid for other works and the order that shall not be coming in way of petitioner's firm. However, this order shall be subject to outcome of the petition of the Lawrence with regard by interim order which will be considered.
But this order shall be,
Well, 5-1 your lordship, after this order, the 5-1 the learned singers are considered. 5-1 your lordship, see page 33.
These 5-1-24 order was
Oh,
passed.
this is the- Huh?
The 5-1-24 order was passed when following the read order, my lord.
Yes.
That's why,
So-
my lord, they were affected, my lord, because, my lord, in a
No, no, they are affected, no doubt. They are no doubt they are affected. But why aren't you? If you look at the single bench order,
My
what does the single bench order say?
Page 33.
What does it say? Page 33, please read. Please read.
Yes, ma'am. Be that as it may.
No, this court.
Yes, ma'am. This court further makes it clear that so far that the works in which the petitioner has submitted his bids, which are subject matter of the observation of this honorable bench. Honorable division bench, the authorities may go ahead with the tender process, finalize the same, but before entering the work order, it is the requested petition from this court. My
So,
lord, and kindly see the pair of the writ petition is not that, my lord. Pair of the writ petition is to, my lord, state the, my lord, blacklisting order, my lord.
correct.
That's why I am submitting, my lord, the coordinate bench, my lord. It gives me additional relief, my lord.
Huh?
But gives me additional relief, my lord. And kindly see the.
Gives, what does it give you?
And kindly see the.
Additional relief.
Additional relief.
Yes, my lord.
Who gives the additional relief?
The coordinate bench, my lord, this.
Correct, correct.
Yes, my lord.
So-
Yes, my lord, kindly see the pair of the writ petition, my lord.
No, Mr. Counsel, my question to you is very simple. You are allowed to go ahead with the tender process
I like the same.
and finalize the same. Have you finalized the same?
Yes, my lord. He become my lord L1, my lord. He is L2, my lord.
You don't understand. It doesn't mean that you finalize the same with the blacklisting order. With the blacklisting order as if it is still in place, you finalize it. That is what it means. You are twisting it around. But the problem is that he has been allowed to participate.
Yes.
So final,
He was black-
but then,
One year, my lord.
no, so but then you finalize, then he's got a right to come in. You see, because even the division bench orders, how can it say subject to the single bench? Anyway,
My lord, one thing is.
My lord,
My
in
lord,
the
kindly
entire-
see the prayer of the.
In the entire order
No,
to
no.
be stated.
No, no, my
Huh?
lord, kindly see.
You know, you also see what order is in there.
No, my lord, kindly see prayer of the petition, whether the court can grant anything access over the.
How is
What
challenging
is
the
the
order?
prayer?
How is
The
challenging the
prayer, my
order?
lord, kindly see the prayer.
it has been passed anyway, whether we like it or not, it's been
My lord,
passed.
if it is something like void, whether my lord will continue, it, that is one thing very important. If I bring to your lordship, my lord, that part of the order is a void. It is beyond the prayer relief sought. In that case, it is a nullity. If it is a nullity, then what happens to
High
that?
Court
My lord,
order is
kindly see
nullity.
the prayer. Prayer, page 49 of his prayer.
The High
There
Court
are
order,
more-
High
yeah.
Court order is nullity, my lord.
Yes, yes, it can be void nullity. I will satisfy her.
No, Mr. Counsel, one thing.
See the prayer.
Please understand. You see, please understand the issue is the court has passed, this court has passed an order. Okay, has passed an order, whether it's right or wrong, that's not, it has passed an order. Now, I cannot say it's a nullity. I cannot say my own order is a nullity. Can I?
My lord, that is why I have filed this application for pro interest issue. That is on that application, my lord can decide. But suppose your court is misled.
The
My
problem is
lord,
you also, just a
suppose-
minute, just a minute. You also are not understanding the import of the order passed by the learned single judge. You can finalize the issue by saying that with view of the blacklisting order, his one is L2, L2 becomes L1.
Because of the practicing order.
Yes, so he becomes L1. So you can ask for a order for leave the court for allotting him the work. Thereafter, he gets a right to come in.
My lord, in fact, I mean, if the stay would have been granted to the blacklisting order, then everywhere wherever I participated, it will only finalize,
You see, the thing is that the blacklisting order has not been stayed.
not stay.
But the problem is, it has made it, I mean, with powerless.
No, my lord,
It has made, because
the reason is that, my lord, the reason is that.
it has made it
after 1
invalid.
month- After 1 month, my lord, the blacklisting order is set aside. And then, my lord, whatever I participated, where I am become ineligible because of blacklisting order, I go. So that cannot be revived. Because the tenders where I am rejected on the blacklisting order, your lordship after 1 month set aside the blacklisting order. So where from the other tenders which have been finalized, what will happen to those? to protect that, my lord, otherwise, my blacklisting order is stayed. Then everywhere where I participated, I become eligible. The works can be allotted to me. Instead of doing that, the court only said that you allow, you finalize, and thereafter we hear the matter. Because that, you're also seeing if the blacklisting order would have been stayed by this number court, then everywhere where I participated, I would become eligible. I can get the order.
So at the end of the day, as on date,
Today, is only for implementation.
blacklisting order has not been stayed.
No,
So you finalize the tender process, keeping in view that the blacklisting order has not been stayed. So he becomes L1.
There is one more point, my lord, what my.
No, I'm saying-
Wherever he has applied for, in Sabarmati company, Indraprasth, GL, all these companies will come before lordship.
Let them come. What to do?
This court should have named jurisdiction at all.
Huh?
Without jurisdiction, my lord, the person comes. My lord,
Let those persons come.
My lord, where it has no jurisdiction, I can understand, my lord, this court.
Then
has
you have got to tell this court, you have got no jurisdiction. Why did you pass that order?
Why I'm submitting, that is I'm submitting, this court, Guwahati High Court has no jurisdiction because there is no whisper in the writ application. Any part of cause of action has taken place. But I am putting one question to myself. This court gets jurisdiction to deal with them. Try, receive and determine the matter. 226(2) has to come in. Well, he show the 1 line that this part of cause of action has arisen.
Why are you
in
so-
Guwahati.
not implicated
In
here?
Guwahati. In Assam, in Assam. Everything, this cannot be settled. But today, US president election is challenged to go warrant to here. It is exactly same thing has been done. That proceeding which is.
So there
going
was no
to
tender
line
process
is
in
not
Assam.
Here, but why your lordship will keep this.
There was no
proceeding alive?
tender process in Assam.
No, nothing, zero.
my lord, I will
But
not,
you know,
reply- I will not reply to
It's
it.
dead
A
horse.
single argument
No, but it's dead horse.
because
Cool
prior
it,
to-
cool it. Yeah, I know that there's a lot of money involved. That's why proportionately your volumes are also going up. But please, you all are arguing so much that you all are
my lord, the-
taking away all the oxygen that is here and leaving nothing to us.
my lord,
We are gasping and you all are shouting. And
accident, my lord, the money
Certainly,
involved,
we need the oxygen too.
I appreciate my lord.
And we are not getting the,
but the
you all
boys,
are getting that proportionate
Well,
amount
well,
of maybe material instructions. That's a different issue.
voice of the lawyers also increases.
I
For some factors, my lord, the lawsuit
I
knows that.
appreciate my lord that really
No.
Assam is such a good place. Pond water of Mumbai, that is
My
coming
lord, I will
here
only submit
and
one thing, my lord.
contaminating, my lord, and
If the lawsuit
contaminating.
permit me, my lord,
And whether my lord will entertain this petition at all, a what proceeding will should be allowed.
I have to
say.
first plead you.
before that, how you, my lord, I will just to satisfy your lawsuit, my lord. My lord, the part of the cause of action must have arisen, it is some part of cause of action. My factory is in Guwahati.
No, that is a different
The
issue.
supply of goods is from Guwahati.
Maybe.
No, my lord, the question is that you're also fine, that it doesn't say that only where the tender is issued. I am supplying the goods from Guwahati in respect of the tender process.
Then what happened if supply is in Japan?
My
The
lord,
factory is in Japan, then what happens?
Japan, because the jurisdiction in the country, 226. is
Why
not
not,
applicable.
why not state?
Well, I will show to you also the
Well,
division
let
bench
him-
of this honorable court. Will not
Let him
declare,
say we are supplied from
Are-
Guwahati.
Anyway, let me hear him.
why
Let,
I should say.
let
I
me
should-
hear, let me hear him.
I will not give a
No,
single
no.
reply.
Let me hear him. I've heard you. Yes.
Is the place of supply.
Please, let's go to your citations. That's all. Otherwise, we are wasting time.
Yes.
Though we are all enjoying your duel here. I mean, our AC needs to be, I think.
I'm really obliged, my lord, that I.
As I said, voice of the lawyers depends on various factors. So as you also said.
But one thing is this, my lord is really keeping everything cool by smiles and all that. We
I'm
are all
also smiling.
getting cool. And yes, and we all getting cool. And that's the best thing.
You see, two of you all,
Yeah.
I'm quite sure with all your shouting,
Yeah.
once you leave this court, you all will go and have tea or something together.
Yes,
Come, I'll treat you to kachori or something. You'll have.
Here also we are laughing, but there is nothing.
Ah. And then you leave the judge all sweaty and hot. You will go and enjoy.
There's a page 12, my lord.
Yes, so please give me the
Page
citation.
21, my lord.
Page 21.
Paragraph 21. Page 12,
Please,
paragraph
you
21.
see, you have given me 14 judgments. Please which
See,
page?
I, your lordship has cut down on this, paragraph 21. Statute may contain any explicit, may not contain.
Paragraph page, which page?
Paragraph 21, page 12.
Page 12.
Yes,
Okay, page 12. Yes,
para 21,
para 21.
Supreme Court.
Yes.
Statute may not contain any explicit provision to hear a third party, but it is not excluded either. Principle of natural justice as well as that of pro interest issue would be applicable in such a situation. And now, my lord, this pro interest issue is well explained in Indian one judgment page. My lord, we kindly come to 14. That is Andhra Pradesh, Hyderabad.
Which page?
Page, my lord, we kindly come page 17.
Para?
My lord, we kindly see at 20, if my lord has come 17, then come near 22, where it is written 20. If for any reason, page 17.
Yes,
My lord,
yes, yes. If for,
if for any reason third party has any legitimate claim over the amount that party cannot be made to suffer by the dominant action of the court, to avoid such hardship to a third party whose interests having been affected on account of dominant action of the court, it is for the court to see that the justice is done when that party approaches that court in the self-same proceeding in which the court has come to be passed. In my considered view, it is a case where the court can entertain this application and pass necessary orders in the interest of justice by invoking the principles of pro interest issue proceeding in view of the judgment passed by Natha such and such, wherein this court has
Okay.
said. The pro interest issue proceedings are a judicial device intended to protect the right of persons who are not parties to the proceeding to the suit but who suffered a legal injury because of the dominant action of this. Paragraph 6. Therefore, the contention of the learned counsel for the first respondent that petitioner has only a remedy of filing a suit cannot be accepted. Of course, application having been filed under provisions of Order 38, Rule 8 CPC is not mentioning of wrong provision is no ground to reject the application provided the application can be maintained otherwise. In view of my above discussion, third parties whose rights have been affected can certainly approach the court and this doctrine of judicial device can be invoked for the reason above. It is allowed, etc. In view of the doctrine of the pro interest issue.
Okay.
My lord, pro interest issue, US Supreme Court full bench.
Okay, next.
My lord, next minute. My lord, again, then I said, crip dot. My lord, one judgment of Supreme Court, all 9 judges together, explaining pro interest issue. My lord, that's a very nice judgment. And there are 2 judgments.
They are all nice.
Supreme Court judgment, Supreme Court.
Supreme Court judgments are all nice. They are all nice judgments. Which one is not a nice judgment? Tell me.
Now they have said obiter dicta is also binding.
If one would kindly see that paragraph 6. Of the judgment, all judges sitting together. That's the beauty.
No one stands in the court and gives judgments. They don't hear. Have you seen any judge standing in the High Court judge standing in the dais and listening and passing orders? Then
No.
I believe we all sit.
Yes.
Mm.
If I read paragraph 6 at the bottom 6th line, no one even in equity is entitled to be made or become a party to the suit unless he has an interest in its object. They made a declaration of this. Yet, it is the common practice of the court to permit strangers to the litigation claiming an interest in the subject matter to intervene on their own behalf to assert their titles. When any person says, Mr. McNeil, this claims to be entitled to an estate or other properties sequestered, whether by mortgage of judgment, lease, otherwise, or has a title paramount to sequestration, we should apply to the court to direct the inquiry whether applicant has any or what interest in the property sequestered. The inquiry is called an examination pro interest issue. That in order for such an exemption may be obtained by a party interested, as well as where the property consists of goods and charges, property, etc. real estate. Thus, in Martin versus a person claiming title to the goods seized under the order, then an order of examination pro ente su, and in the meantime that the goods might be restored to him on giving it to scrutiny. The same practice prevails in cases where property is put into the hands of receiver. Daniel CJ, the ground of this procedure and a duty to the court to prevent its process from being abused to the injury of the third person and to protect his officers in his own custody of the property in their possession and to defend and preserve his jurisdiction. For no one is allowed to question or disturb the possession except by leave of the court. So the equitable power of the court of law over their own process to prevent abuse, oppression, injustice are inherent and equally extensive, inefficient, as is also their power to protect their own jurisdiction and officers in possession of the property, and that is in the custody of law. Such and such, when in the existence of power, it becomes necessary to forbid the strangers to the action, the resort to the ordinary remedies of the law for the restoration of the property. In that situation, as happens when otherwise conflict of jurisdiction must arise between the courts of the United States and several other courts, because he is deprived of the plume and adequate remedy of law, and the question of citizenship which might become material as an element of jurisdiction. United States proceeding is pending, it is awaiting the.
This is, how does it, this is, they're talking about the external censorship. Don't read everything, we
That is
don't.
the concept of this, that when an order of the court affects a party, and in that case, that he can come in the pending proceeding and get a stay and to restore the property. Following this, my lord, what happens? Suppose my lord gives the property to a receiver. Receiver is an officer of court, and some third person's property has come in the hand of receiver. He cannot go and snatch the property from him. What he says, that is the officer of the court is protected. Then what he has to come? He has to come to the court, say that this is my property has been taken by the receiver. Give me, he need not be a necessary party for that. This is what clarified when this judgment was relied.
So right, so according to you right now,
Yes,
the supply order should be in your pocket.
my lord.
Next.
Well,
Anything else?
This, Joseph just more, no?
Look, Mr. Counsel, you have given me a compilation of 14 judgments.
No, all won't be relied upon.
And you're relying upon loose
But
judgments again.
What happened was is that was the issue which we have earlier made.
How
for
many judgments are you relying
No,
upon?
no, but these are not, there is two more, or on the same point, but on the English.
Don't give me on the same point.
It is the same point.
Give me the same point. How does it help?
But one judgment, English court judgment, I give and finish the matter.
Yes, you can give the Supreme Court judgment.
Yes,
That's all.
Supreme Court I have given one.
Okay.
Supreme Court one.
So you
And
don't have
so
any other Supreme Court judgment.
So there are other high court judgments which I had that.
On the same point, no point.
No, same point, on the same point.
On same point, no point.
So point, no point. So only one I can give cricket, which is cricket. That para 356,
So basically, a case is that pro interest says so.
yes, that is.
That is your entire case.
Yeah, that is my entire case, that I am affected by the order and it is not only him. The second response number 2, at various other parties, he says wherever he has participated, but where somewhere I am L1, those orders are, but is it supposed that all over India will come here for purpose of obtaining that he grant us order, permission to pass final orders where they are in Mumbai, Madras, Coimbatore, and they will come here? But this court should have that kind of a plenary jurisdiction, that what anybody residing in India will be within the domain of this 226(2) does not give. But this is a ward proceeding. If it is a ward, then Supreme Court says ward ab initio. This extension order, this affidavit, this etc. all renders void when your lordship decides this court has no jurisdiction. When this court has no jurisdiction, what the court will say-
No. Let us not go into that. Let us first go into the impediment issue.
Yes, my lord, yes, implement issue of that, I am affected. So I'm really, yes, yes.
Which page,
Well,
which para?
Please, if you can see the page 3.
Yes,
Well, page 3 is, if I come to the just 3 lines, I will read them in substance. Therefore,
which para?
this is from the judgment of the Lord Cloris Casey, no paragraphing is given in that. Second paragraph. At page 3, at the top, second paragraph, page 3. At the bottom of this, Sir Edward Clark is given at the bottom 3 lines. In
Yes.
substance, therefore, a party to the intervening becomes in reality plaintiff in the whole litigation, and probably he or she may still be substantial portion against remedy may be had, etc. Then the second judge who also delivers it, that person can intervene in the proceeding after getting a leave. He becomes a party in the proceeding. Then my lord, can we come to page 5? I'm just going very fast and my lord, can you see page 6, my lord? You can page 6 that the judgment of Susan Hardy is rather very we can size, my lord. Some page 6.
This,
Judgment of the Cousins Hardy LG. Some difficulty has occasioned by reason of peculiar positions of interveners. Interveners were not known to the common law courts, and I think there is a policy in attempting to treat an intervener as though by such an order as was made in the present case, he or she becomes for all purposes a co-plaintiff. That cannot be so because co-plaintiff have no right to.
what are the facts of this case?
Well, facts of this case were this, that a person was not a party to the original proceeding. But when he was not a party, his properties were he got it by inheritance of that in that property. And when in a probate proceeding, a suit was filed, then he claimed that I am the owner, so pro interest, so let me be treated as the plaintiff. So these are the things I am submitting, my simple at this stage. By this order, I am a participant of a tender. If I do not say that I am L1 or L2, my right is infringed if I am a participant of it. And if I am a participant of any of the tender where he has participated,
Okay.
I have the right.
Okay.
There are 2 lines, if you want to project me. 2 lines only. One, philosophy will mark it, also. Everybody to mention without legal right. Philosophy must see me first. Secondly, the judgment which has been placed for lawsuit are intervener. Now the application is for impediment and the party is problem. And the division bench judgment of this order court was also with regard to the intervener. I've given both sides, intervener as well as the impediment. I will not.
What is the difference between impediment and intervener?
Intervener has no right. Intervener can only support the one side or other, but he has no right to give fresh materials before the court. So judgments are there. Intervener, because his application was for impediment only. Now, since he said that his prayer was for only for the stay of the blacklisting order, and this order was passed. And I never in my practice, 34 years at least, I've never heard the argument being advanced before the lawsuit that the lawsuit's order is nullity, void in issue. I at least to the best of-
He can make an argument. How
Well, argument also that the certain things are there. In the appellate court,
I have borrowed Supreme Court's words.
Please, I'm not arguing something, I'm just making submissions that, I leave it on that issue also, the issue of which has been decided by lawsuit, that whether a legal and proper party, necessary party and commercial interest. If your lawsuit can examine it, that will be an issue.
We'll see now. Now, the problem is,
Other people are all waiting,
I know. Okay, right. Third, Mr.
Sudhir Mehta.
Sudhir Mehta, learned counsel for the applicant.
With Mr. Vipul Kundalia.
Huh?
With Mr. Vipul Kundalia.
You need it for what? Material instructions?
No, he's assisting me.
Well, material instructions will not be in the court.
He's assisting me in the matter.
No, I was saying, but you're not a senior. Then where's the question of being assisted?
As yours.
Yeah. for the applicant, huh? Also heard Mr. Dr. B. Saraf, not Mr. Dr. B. Saraf, A. Saraf, learned senior counsel for the respondent number,
Respond, both the respond.
or both the respondent. Respondent numbers. Huh? You know,
No, no, it's PCL, not a party. PCL is also.
Officially not a party. Only the petitioners.
but they are parties in the main writ petition. What is this, Mr. Counsel?
My cost title in my application, my lord, I have given full cost title of the
That is a
petition.
writ petition.
Writ petition, and we serve them and.
No, no, but the others are also, the others
served
also
them.
parties.
We have
No,
served-
no, but they are not parties in their cost title, they're not mentioned.
No, no,
Where?
not there.
No,
My lord, page-
show me your petition.
my lord, can you see page 1?
Page 4, my lord.
How come your petition is so thick and mine is so thin? Huh?
Page 4 is the cost title.
It
Page
is,
4.
we are bound with.
I've got page 4.
Page 4 is the cost title.
This is the writ appeal, Mr. Counsel, this is not your application.
IA, my lord, you also see page 4, my lord. IA. In the introductory application.
Huh?
Introductory application, page 4.
I know.
That is the only, my lord, earlier was the writ petition and respondent.
No, page 1, this is interlocutory application number.
Yes.
Here.
But that's it, लिखी हुई है। Both it question. The petition response.
Why don't we, I have the same copy as you all have all thick copies
We have compiled all together, read and for our own.
for yourself and you're giving me this.
This is the petition which we have, application which was filed, and our copy is coupled with the writ application, their appeal and everything together for
So
our.
you all have everything, I have nothing.
But this is this, in the matter of this petitioner Gupta versus 1, 2, 3, 4, 5, 6, all are there. Thereafter again, we have given applicant, after giving the full cost title, I have given the applicant. Then I have given these two, they were opposite parties to me because I am not seeking any relief from the other person. So my relief is only from these two who are.
Okay, anyway, their names are here.
Yes.
Okay. Right, Dr. A. Saraf, learned counsel for the respondents number 1 and 2. Assisted by Mr. NN Datta. Mr. Bhattakur, S. Bhattakur appears for?
He is not there, but. IA is not a party.
Anyway,
I lost him a hearing also.
I've heard you. Any objection to the application? Any objection to the application? Mr. S. Bhattakur appearing for? Respondent number, no, not this, who are you? Who are you?
Bharat Petroleum
The
Corporation.
Bharat Petroleum appears for the Bharat Petroleum Corporation Limited, while Mr. K. Goy appears for the Ministry of Petroleum and Natural, appears for the Secretary to the Government of India, Ministry of Petroleum and Natural Gas. No time to pass order now. Hearing concluded, order reserved.
If you lost it, we've been liberty, I may look at Spanish, write the side of paragraph numbers, which I like. In my comparison, if you also permit me, I may write the paragraph so it may become inconvenient for you also.
Sure.
In the index itself, I just keep me look back. Highly obliged not for the passage.
Very, yes, anyway, I think your client should be happy. They'll be watching.
It's always pleasure.
They'll say that
It's always a pleasure to argue for Lordship.
They'll say money well spent.
Your lordship, whether that bread and breakfast matter.
Very well.
Your lordship on the last occasion asked my lord what is the status of the
Yes,
wine
yes.
license.
Yes.
Now, my lord, I have filed an additional affidavit, it's on record, my lord.
Huh?
We have filed an additional affidavit.
And what is there?
My lord, that we have applied within the time period.
But
prescribed.
no approval
Approval
given.
of the, my lord, Minister of Tourism has been granted, but the certificate is yet to come. That is,
Where is the approval granted?
one of the, okay, it's not okay. This is there on record, my lord, the additional affidavit.
Where is that?
My lord, page 122, the first annexure. That is the application that we have applied for re-registration. They call it reclassification.
You applied on the one day before.
Yes, my lord. 29/30th, my lord. And page 123, your lordship will find. That is the NIDI document. Your request for showcasing your unit, NIDI, the database has been approved by the competent authority. Now, my lord, it has got 5 steps. 3 steps have been completed. The certificate is yet to come to hand. That is the correct question.
It just says your request for showcasing. What does it mean, showcasing?
That is what, my lord, their guidelines say. Guidelines your lordship will find at, my lord, page 83.
Page 83.
My lord, those are the guidelines.
Yes.
It starts relevant, it starts at page 86. Common national and standard guidelines for classification of Incredible India Bed and Breakfast Establishment and Incredible India Homestay Establishment. Now, so far as renewal is concerned, my lord, they use the word reclassification. If your
Yeah.
lordship kindly comes to page 87, clause 4 is the relevant clause. Classification will be valid for 2 years from the date of issue of the order, and or in case of reclassification from the date of expiry of the last classification, provided that the application has been received within the stipulated time, that is 3 months before the expiry of the previous classification. So one can apply before the expiry any day from 3 months onwards. So we applied on time within the time prescribed.
No, you did not apply within the time prescribed.
From 3 months prior, you can apply any date, not prior to that. And the
It says, provided the application has been received within the stipulated time, that is 3 months before the expiry of the previous class.
So from 31st of January, we could have applied in November, my lord.
No,
From November onwards.
no. You
Because the
applied
next
on
month-
30 January. So how can you apply for a period prior to that?
No, we are not applying for a period prior to that because it is valid up to 31st of January. That your lordship notice.
That's
my lord. Page 10.
But how, you see, the issue is this. Your request, the words used here is your request for showcasing your unit. Now, what it just says showcasing your unit has been received, has been approved. What does it mean, showcasing your unit? That's the word showcasing, what does it mean?
If your lordship kindly comes to page 127, my lord.
Is it there in the application form, that word showcasing?
Yes, that is in the guidelines also they would do.
Let us see, let us see.
Because they put it in the website so that my lord, the prospective
So
customer
you
can
have
see.
downloaded the form, no?
No, it has to be online.
Correct, but then so that we can understand what is the meaning of showcasing. Does it mean that your request for extension has been approved or something like that? You have got to understand the meaning of the word showcasing. How can we just say that
Yes, Malak. If
it
your
is
lordship
an
kindly-
application for extension?
If your lordship kindly comes to page 89, clause 14.
89, yes.
All cases of classification will be finalized within 30 days of the application, complete in all respect and free from all deficiencies being made online, and online confirmation of the receipt of application fee by PN Accounts Office, Ministry of Tourism. So that we have got, my lord, at page 122, we have got that. And they have congratulated us for accepting it. The fees also, my lord, they have accepted. So, my lord, the process may take, my lord, 1 month from the date of application. My lord, as your lordship is aware, my lord, in Assam, we do not have any specific guidelines. But if your lordship permits me, there is a set of guidelines for the Department of Tourism in Tamil Nadu.
No, you see, you're just to convince me on this word showcasing. That's all. I don't need
Other
other things. Yes, you convince me on this. That's enough.
If your lordship kindly comes to my additional affidavit, at page 125, your lordship will find, my lord, what are the steps that is required, my lord.
Yes.
We have to log in online. Your lordship will on the right,
Yes.
right and bottom, your lordship will find, my lord, the name of the petitioner. The first step is basic information and document upload.
Yes.
The second step is desktop verification and scrutiny. So these steps have been complete. Then remote outside assessment, applicant will be assessed on the defined parameters remotely or on-site as the case may be. Then approval by the competent authority, then only, my lord, the certificate will come.
Correct.
Next page. That stage is yet to come, but if your lordship comes to next page again, then your lordship will find the three, yes. Basic information and documents, status is there. Showcasing form submitted. Next, desktop verification in progress. And third stage is get published and live. So that is yet to be published. So verification is complete.
So unless it is published, can we say that there has been an approval?
We do not have the, my lord, we do not have the certificate in hand, my lord, right? That is true.
Then what do we do
Now, my
in
lord,
the meantime?
my question, my lord, my submission to your lordship is that, my lord, my learned friend also may have some instruction because it was only because the so-called notice your lordship is seen and that was issued prior to the, my lord, expiry of 31st of January. And we have shown that there is no provision for bread and breakfast. And we have also said that if there is any provision, you can.
No, that aspect is okay.
Right.
That aspect of we will decide that issue at the time comes. As on now, he has not been able to show that there is any separate permission required for bed and breakfast. It's only for homestay. And you had applied for homestay, though you were actually a bed and breakfast facility.
True, my
So that issue we will see. It now the problem is with regard to the interim order. That is what you want. Or if you don't want the interim order, we can wait for some time to. That is the problem now. Can we pass an interim order in the absence of you being able to prove that your thing has been extended?
Or maybe, my lord, perhaps, I understand, my lord, your lordship's, the
Anxiety.
your lordship has. Your lordship may perhaps say, my lord, the moment we get the certificate, either we approach your lordship or, my lord, we give it to the, my lord, the municipality so that we can run. Now we have stopped our business.
In the mean, as an interim measure only. Because the entire thing will have to be decided after
We
they file an affidavit. They have to be given some opportunity of being heard.
True, my.
We cannot decide the entire matter like this.
But in another matter, of course, somehow similar in nature, your lordship passed an order, of course, my lord, subject to what your lordship may say. Here, my lord, the particular, my lord, the business was sealed. And the petitioner did not have the renewal of the trade license. In paragraph 9, your lordship has dealt with that.
No, this is, you see, this issue is slightly different. This issue will have to be slightly, I mean, they have to be carefully done because one aspect of the matter is you you had been given that homestay license, you had applied for it because there was no bread and breakfast facility provision in the rules. So it cannot be this, maybe the import of this can be taken into consideration, but I don't think it'll be proper to decide.
Before lordship is that, my lord, the Ministry of Tourism or NIDI has not taken any action against that. They have not said that you cannot operate. It is only GMC.
I know,
States on
but
my-
still, the document show that the license is expired. From this side, from the ministry side.
Well, the young man was starting a business.
I know, no. You see, if you had all the papers in order, there was no reason not to give you any interim order. But when your papers are not in order and you ask that you should be given permission to continue with your business in the absence of proper documents, it would not be proper, especially when that document has been pointed out to you.
My lord, if I may submit, my lord, Assam does not have any specific guidelines on this, my lord. What happens if the renewal does not count? Does it
No, so we will say that right now, we'll allow the, we'll, as soon as the ministry letter comes, approval, you continue your business. In the meantime, let them file their affidavit.
My lord, the Tamil Nadu guidelines throw some light on that, my lord. May I
Okay.
draw your lordship attention
Yeah.
to the guidelines for registration and classification. On the same, my lord, central guideline, they have clarified regarding renewal of registration, my lord, that will be, page number is not there, not clause 8, last but one page of that batch.
Yes,
Clause 8 is renewal of registration.
yes.
The application for renewal of registration has to be submitted online at least 3 months before the expiry of the registration to the Department of Tourism. Any delay in submission of application for renewal of registration will be accepted for a maximum period of 2 months from the expiry of registration with a penalty of rupees 5,000. Then if the application for renewal of registration is not submitted within 2 months after the expiry of the registration, then the registration will be cancelled and the facility will be shut down. So, my lord, this means that
So it will continue till
Till 2 months.
the implication. But then this is Tamil Nadu, this is not, this is, central government doesn't, show me where the central government has a similar provision.
in the, at the, my lord, central guidelines, page 90. That is the last page of the guidelines.
Why don't you look in the central government guidelines whether similar thing is there?
Other states have done, my lord, Assam has not done. You're
No,
also,
no, that's okay, but whether the central government has a similar guideline,
it is silent, by.
huh?
It is silent.
Then how can we
It is
follow
silent,
this?
by lord. It also does not say, my lord, any penal action if you do not apply within time.
No, I'm not on that. Once the license has been, once the license has expired, can you continue to do the job in the absence of a license? That's the issue.
That is, but it is silent, my lord, that on expiry, before the renewal, you have to shut down your business. That will be, my lord, very, it's a panel, my lord, provision. In fact, my lord, even in trade license, they can apply anytime and they can grant it anytime.
Okay, right. Yes, I think you file an affidavit.
I'll file my affidavit at the same time to expedite the Nidhi may be made party.
Who?
Nidhi will receiving
I
it.
don't have any grievance against them.
Nidhi doesn't have a agreement. You can put whatever you want in your affidavit. In the meantime, let them continue.
But let-
Because since they have already submitted an application for renewal and there is nothing to show that he has not been allowed to continue. This is a small business. He's
Small business system, what's
Huh.
turn to, then if you note, I'm on 115.
115.
Order dated 21/2024.
Yes.
This notice under, these are the sections. MS Hillview, and the address is the flat.
Huh?
Of a building, particular flat of a building. It's
Ah.
a multi-story building, particular flat of a building.
Yes. Yes.
What will come to
Public
second paragraph.
complaint. Huh?
Second paragraph, and whereas during the time of inspection, it was observed that you were running the homestay
In a residential.
in
apartment.
invalid trade license in a residential apartment. And whereas you have failed to submit a NOC from the resident of the Ideal Hill View complex till date. And there is no objection certificate not been filed from the building, the residents of the building or the society. A residence in the society building comes with a, that we have no.
They have got their own laws. They have got their
Because-
own rules.
They-
Yes,
We have answered to that, my
have
lord.
you taken the thing?
My
that
lord,
is-
no society has been formed, and we have shown, my lord, in the petition itself that the residents have given us no objection for that. And my lord, the flat was purchased with the condition that my lord, the bread and breakfast will be open there.
Well, that is a different thing.
And no objection, my lord, what is the complaint? They do not give us the copy of the complaint.
Now, Lord, we'll
Who
come
has
to page
given
number
the complaint?
67. How the tenancy was given.
The
Tenancy
builder has
start from the
given, my lord,
67.
builder has given an NOC, society is yet to be formed. That
Page number
NOC we have
67, paragraph
annexed.
number 5.
On the basis of some complaint, some public.
Last line, minor of the paragraph number 5. The tenant will not. For the NOC permission from the building management society.
Your worship will kindly see our reply because they had issued a proposal notice, we had shown cause.
I think best you get that permission from the thing, otherwise the problem. Right.
My lord, how does my lord, the municipality get the benefit by, my lord,
No, no.
my livelihood?
I'm not on that. Once you get your approval from the ministry, you carry on for the time being.
For the time being, let me, my lord.
You get your approval from at least, there has to be some basis. Since this court has already brought out that issue. Now to allow you to continue without that approval will be a problem.
Lots will keep it pending. In the meantime, my lord, I will file my affidavit at the center when I mention, my lord, he gets the document, then he can mention it.
No, we have given the reply. I'll show that you have not considered my reply at all. I have shown cause.
I think you should get the approval. Because otherwise, you please, you give an interpretation to that word,
Okay.
Showcasing is, my lord.
showcasing, that your request for showcasing has been approved. What is your showcasing? I don't know, you don't know, and neither do I.
Apparently, we showcase means someone will come and inspect.
No,
That's-
no,
it
no.
seems like-
Showcasing
it
is
seems
that,
like
my
that,
lord,
my lord.
one can have the benefit of, my lord, using that and purchasing the service there.
Correct.
That is showcasing.
You get you clarify this. When do you want to clarify?
My lord, it may take 1 month time. That is when I'm.
Huh?
Because the guidelines from the guidelines, it may take 1 month time from.
Because that approval has to be given.
Approval has been given, but the certificate is yet to be, my lord. Yes.
Show me that. If you can prove that, that's enough, but you're not able to show that. Right. Mr. M.K. Chowdhury, Learned Senior Counsel appearing for the petitioners, submits that the petitioner applied for renewal of his license as a bread and breakfast facility with the Ministry of Tourism, while application dated 30/01/2024. A reply was made on the same date stating that the petitioner's request for showcasing his unit had been approved by the competent authority. Full stop. The petitioner's counsel shall obtain instructions with regard to whether the word showcasing in the reply dated 30/1/2024 amounts to approval for renewal of the petitioner's license by the Ministry of Tourism.
My lord, my previously it did come in the first week because within 1 month the document has to come.
List the matter when
First of or second of March,
That's not second.
second, third, whichever is convenient to your lord.
14th Monday, my lord.
fourth.
Highly okay.
Pending 21 and 22.
You put this also.
Well, only yesterday I put the Paravas cover. If Lordship allowed, I can file a short affidavit or Lordship may rely.
What is it? What does it say?
It says that, my lord, they verify. And my lord, yes, it's otherwise in favor, my lord. Lordship may
Okay.
send
Okay, right.
The annex as well.
Heard, Mr. Hedar, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned counsel for the state respondents,
PWD.
for the PWD.
Lordship will have a look at para 9. I have both the Paravas and the annex. My lord.
Just a minute. One case at a time, huh? Now we'll do 2827. The petitioner's grievance is the non-payment of his contractual dues after execution of his contract works amounting to rupees 22,67,537. In respect of, where is the tender, NIT? In respect of, in connection with, take the synopsis, sir. Synopsis from here to here, okay. The next para, the petitioner had earlier approached this court by way of WPC 3217/2011, which was disposed of by an order dated 24/6/2011, directing the respondents, that is the PWD, to deal with the grievance of the petitioner in accordance with the decision of the full bench of this court in Tamsher Ali and others was State of Assam and others reported in 2008, 4 GLT 1, bracket FB. Mr. B. Gogoi has submitted the letter, the parawise comments given to him by the executive engineer PWRD Dibrugarh dated 15/2/2024, which had been sent to him, the
The chief engineer's officers provided me with this Paravas. A copy has been furnished to me also. By the
which had been sent to the chief engineer PWD roads, the office of the chief engineer PWD roads had thereafter communicated the same to the petitioner. In terms of the parawise comments and the letter dated 15 to no, in terms of the parawise comments which has been forwarded to the executive engineer which has been forwarded by the executive engineer to the chief engineer PWD roads by letter dated 15/2/2024, it has been stated
and 11 to 1.
it has been stated that the genuineness of the claim of the petitioner was verified on available papers in the office, on the basis of available papers in the office, and the same was informed to the chief engineer's office by letter dated 24/2/22. Full stop.
11 to 1.
The findings of the findings which are communicated to the chief engineer. No, that's I've already stated. 11 does not say the amount.
No, 11 last line, madam. As per the earlier order of the honorable court, his name should have been in the chronological list as per Tamsher Ali. It is not there.
Full stop.
That-
However,
that-
no, however, the, however, no, what have I said? Full stop. The chief engineer's office was informed. And no, before that, you see, the name of the petitioner was not found in the original chronological list available in the office for payment of his outstanding liabilities. And the findings were communicated to the chief engineer's office by order dated 24/2/2022. Full stop. He submits that, no, the letter, the Parawise comments further states that budget for the amount of rupees 2,26, no, 22,67,537 was received from the chief engineer's office wide number DIB/PWR/003-DIV 2021-22 bracket 1/60 dated 12/1/22. He accordingly submits that the the next para, Mr. B. Gogoi submits that the petitioner is to be given his outstanding liability as mentioned above.
No, madam, only thing, last line, madam, the chief engineer may do a further
Well,
verification.
Mr. B.
Before
Gogoi
the
submits that in view of the Parawise comments, a further verification may be done by the chief engineer's office,
My lord,
and thereafter
my lord.
the admitted amount should be paid to the petitioner.
Lord.
Full stop. Next, correct?
Time frame, madam.
Next, on considering the letter dated 15/2/24, the Parawise comments dated 15/2/24,
Yes.
and the letter and the further letter dated 24/2/24, written by the executive engineer PWRD Dibrugarh, instead of that, what is it? Written by the respondent number better. Written by the respondent number 6. This writ petition is disposed of with a direction to the chief engineer PWD Roads to have a further verification with regard to the admitted amount payable to the petition. Full stop. Thereafter, the admitted amount should be paid to the petition. The entire exercise should be concluded within a period of
Leave it there.
2 months.
Maybe 3 months, budget station is here, but let it be
2 months, I think.
within the 3 months.
Within a period of 3 months from the date of receipt of a copy of this order. The writ petition is accordingly disposed of.
Well, instead of admitted amount, Lord, she will say whatever amount is found due after verification should be paid. Only found, otherwise the purpose of verification won't be there.
Okay, found due after verification. Found due after verification.
Next, madam, is-
The above letters dated 15/2/2024, Parawise comment. And the further letter dated 24/2/2022 are made a part of the record and marked as Annexure X collectively.
The next case, the date of the letter will be different. Now.
In the next case, that is
2830.
2830, the amount is how much is the amount?
21,75,376.
Let me see. 21,75,376, correct? Out here, the letter is
It is 20,
same.
21.
No, except the last letter, it will be 20,01,20.
Twenty.
Okay,
Obligor.
Obligor. Give this. What is that? To whom? Which one? In which case?
These are the not relevant. I have given.
Give it back. Yes,
Wait, your lordship, in item 30, our signed affidavit is here. We will be
29.
filing it, today.
29.
In 30. And in 20, lordship, some subsequent developments have taken place, which is why, lordship, we need 2 more weeks to,
29, what do you want?
we need 2 more weeks to file the affidavit. But in the next item, lordship, we will be filing it.
What happened to your appeal?
Well, appeal has been dismissed.
Dismissed.
No.
So he wants some time. Mister,
I brought up
I bought a code is granted,
2 weeks, lordship,
2 weeks time to file, what?
counter affidavit.
Affidavit deposition, leave the matter after 2 weeks. Then item 30,
In item 30, we will be filing it tomorrow, lordship.
Mr. S. Bhattakur submits that he will be filing.
I-
Item, he'll be filing affidavit in a position tomorrow. This is the matter after review.
मतलब मेरे पे for date में confident that मतलब
Okay, 2 weeks.
32.
Give a date for that item 30. 30, item 30. Yes, madam.
Kindly see order dated 24/1/2024. Time was granted to
Item 20, which order? 24/1.
24/1.
Yes, who is appearing?
Some further time may be given, Mother. I will have the instruction.
Huh?
Some further time may be given to have the instruction. Otherwise,
There was an earlier writ petition also.
yes. Of 2021.
Yes,
Okay, Pan will have to come from them. PWD is the only the executive authority.
huh?
After 2 weeks.
Why? Why 2 weeks?
That's I have to take instruction.
The administrator is clear, but then this matter is of, this matter is
23 lots.
23 September it was listed, this money. And the earlier writ petition was there also.
Lordship.
Then?
Otherwise, Lordship, amount is admitted.
Where?
So, Lordship.
I know it's admitted, but then
Lordship,
despite the order passed by this court earlier, it's not been paid.
Only because of fund loss. In
Now you make sure this is the end of the financial year. You've got enough funds now, probably.
March, Lordship.
You see, the earlier order of this
Yes,
court is
Lordship.
there, then
Lordship.
who do we call otherwise? We'll call the
No,
officer.
not
Huh?
Lordship.
When will you,
Or Lordship, may dispose of this case also, Lordship.
no, I'm not disposing. I'm not going to dispose. You're not going to obey.
Lordship, may fix it.
You-
After 2 weeks.
You
Lordship.
you don't care about the order of this court. So why should I give you that opportunity? Now I can call him. When should I call him? You're not paying, you're not obeying.
I'll take Lordship, initial, required instruction. So Lordship, fix may be the next week, Lordship.
Post of right. Mr. N. Upadhyay submits that he will obtain instructions with regard to non-payment of bills amounting to rupees 9,52,500. On a perusal of, no, it is also noticed that by order dated 9/11/21 passed in WPC 1696 of 2021, the respondents were to dispose of the petitioner's claim in terms of Tamsher Ali and others were state of Assam and others. Huh? So, okay, the GL 2008 4 GLT 1 MB. Pustak. However, as the same was not done, the petitioner has filed this case again in the year 2023. Mr. Upadhyay shall obtain instructions by the next date, list the matter when.
Lordship, after 10 days, Lord.
Give a date.
Lordship.
Money, this is time frame for 2 weeks time, we file affidavit in matter.
Mr. Sutia, letter counsel for
GMC matter.
GMC. Is granted 2 weeks time to file affidavit of appeal.
Date may be fixed. There is a small business enterprise, my lord, the payment of 27 lakhs is pending, my lord. Therefore, my lord.
It's a very new case. If you positively file, madam, he needs money.
Obliging.
Yes,
May it please your lordship, immediate amount, my lord. My lord,
where is the admission?
my lord, they are absent, my lord. My lord, on the last occasion also, they were, the council who was representing BTC, but, okay.
Yes. When are you paying? No, he says that it is admitted amount. Is it admitted?
Yes, my lord.
Where?
Kindly come to page 38, man.
Okay.
38. This is the letter from additional director come CSD Tribal Affairs BTC to Secretary Tribal Affairs. Sir. Kindly come to the last paragraph, madam. In this regard, demand for sanction of fund in favor of so and so amounting to 8 crores and odd submitted to your kind in right letter number so and so 8 June 2022 and demand of rupees 11 crore and odd only in favor of Messrs. So and so was submitted by letter number so and so 8 June 2022 respectively. But fund has not been sanctioned till date. My lord, my entire life is blocked in this matter.
1 week time.
Huh?
1 week more time.
Okay, Mr.
RK Musari,
R.K. Mushari, learned counsel for the
standing on BTC.
Huh?
BTC. standing on
BTC. And
A Longcomer,
A.
Longcomer on behalf of Mr. Arthur.
A. Lamkomer on behalf of Mr. Ardha, learned counsel for
Tribal Affairs.
Tribal Affairs. Is granted 1 week's time to obtain instructions with regard to why the admitted amount. The amount paid by the petitioner is not paid. Keeping in view, the letter dated 27/9/23 issued by the additional director come CHD Tribal Affairs bracket P BTC. Bracket page 38. List the matter on, give a date.
My lord, next week, my lord. My lord, only thing is, my lord, March is coming, my lord.
Give
Otherwise,
next week.
financial year will go, my lord.
Because it is there's a letter. There's a letter.
Public.
Mr.
The next
Counsel,
is-
one thing is if you do not obtain instructions, we are going to call your official. So please take it seriously.
My lord, the next is also same, my lord.
Item,
34.
same order, same.
Same issue.
Why? Okay, yes,
Same,
same. Make it in one order.
oblige, my lord.
This is 37, 38, huh?
37 and 30, Lordship, our affidavit is sent for vetting, Lordship.
Okay, Mr. K. Gowai submits that the affidavit in opposition has been sent for vetting.
Lordship.
He accordingly pays for
Then within 10 days, we will.
10 days time. List the matter after 10 days.
And correspondent one.
Are you filing any affidavit?
We are awaiting instructions for 1 and 2
Miss
for Revenue Department
S. Bora
and border law.
and Bordoloi. Appearing for the respondents number 1 and 2.
1 and 2 in item 37 and respondent number 2 in item.
Which is the department?
Revenue Department and DLR Department.
Appearing for the,
IGR Department, IGR.
don't say 1 and 2, just say appearing for the appearing for the Revenue Department
And the Inspector General of
and the Inspector General of Police,
Registration,
the bracket registration,
not police,
Uh,
registration, only registration.
IGR, Inspector General Registration is granted 2 weeks time to obtain instructions and file affidavit. This is the matter of two.
Pledge.
Any date may be given, any date may be.
Next.
Sorry, I think 39.
Paid bill, my lord. Matter pertains to non-payment of my bill, my lord. I rented out my vehicle for administrative purpose, my lord.
So where is the admission?
My lord, the admission, my lord, would find at page 25, my lord. Page 25, point 4, my lord. My lord would kindly come. If I may read, my lord. Since the beginning of the agreement with your client on 8/2/22, this office has regularly paid his dues up to the month of March 23. Despite of many shortcomings in his service, as described in paragraph 3 above.
What is this? This is a council or what?
My lord, we had sent a legal notice to them, my lord.
You are the council for customs or what? What is this?
No, my lord. My lord, what had happened in the case is
For,
that
for vehicle hire or what?
my lord, what had happened? We had sent them a legal notice.
What is the issue?
My
The
lord,
money is
vehicle-
for what?
Vehicle hire, vehicle
That's what
hire.
I'm saying. That's enough. Don't have to say when you were born and what you were wearing. Yes,
Allow us 10 days time to file our activity, Lordship.
Miss
M. Deka,
M.
Deka,
Deka appearing for
Lordship.
for all the respondents.
Yes, Lordship.
All the respondents granted 10 days time to file affidavit in position. This is the matter of 10 days.
My lord, they have already made part payment regarding this. If I may submit before the.
You
honorable-
file an additional affidavit.
Much of that.
Obliged.
Pursuant to the, my lord, interim order, the petitioner was allowed to participate in the subsequent tender notification. Subsequent tender process. Pursuant to the interim
Consequent to
order-
what?
Pursuant to the.
Pursuant to the NIT.
Pursuant to the, matlab, initially in a tender process, he was the third. But the authority said you quote your rate in a different manner. So that the settlement can be given to him. So ultimately, they canceled my whole process and said subsequently you cannot declare in the tender process. So I came before the court said subsequently that interim order was given that allowing me to participate in the subsequent process. And regarding my lord, now only issue left is that security money. Court said it is left to the authorities to decide the matter. Further, there shall also not be any power for the department to consider the prayer for. release
No,
of
no,
the
tell
call
me one
deposit.
thing. If you have participated in a tender
Yes,
process,
now the call deposit amount.
what has happened to the tender process? You did not get it.
No, the first tender process, I think government has tender, the authorities have cancelled it. And second tender process they have issued. And but by the impugn order, they said.
Which
you
is
cannot
the impugn
participate.
order?
Impugn order is a page 441. Before that, your lordship may kindly see page 37.
Just a minute.
They misquoted this rule 48.
Okay, so
But-
you,
but
you,
he
you,
is not the authority, my lord. Deputy commissioner is not the authority. Ultimately, the question arose before the court is deputy commissioner is not the authority. So therefore, the second tender was issued. Your lordship may kindly say page 37.
So the earlier tender process was cancelled by the order of the deputy commissioner.
By the order of the deputy.
It was cancelled and your
My call money was.
call deposit was forfeited.
Forfeited and I was prohibited from participating in.
But why was your call deposit forfeited?
Because my lord, I did not submit the tender as per their suggestion,
Okay, as per the suggestion.
their suggestion.
You submitted your tender anyway.
Here I
As per
submitted-
your
We quoted my first year
you-
with less money, second year less money, third year I increased the rate. That is how I have my
so
condition.
they wanted you to change the rate
Changed the rate.
and you did not do it.
I did not do it. So but deputy commissioner has issued the order.
Yes, who is appearing?
Now, only thing is that, my lord, in the second process, person to the interim order, they have allowed me to participate in the second tender process. But the call money deposit is there.
That has not been, so you want the release
call
of the money?
deposit should be returned to me as per law.
Yes,
Lordship, this is not by the fishery department, this was done by the DC, deputy commissioner.
This is not the authority, my lord, government actually.
where is the impugned order?
Page
Page 41.
14.
48, Lordship, and
48, not 41.
Assam fishery rules, 48
No, he is saying about rule.
rule.
Can the DC pass an order?
Lordship, DC
Cancelling
can
the-
cancel it because DC has issued it.
Ah.
That's not a disputed fact.
But what
Yeah,
about
yeah,
the
regarding that part,
forfeiture?
officer is, has to go to the fishery department. He cannot take the decision as per my understanding.
Where is the law? So who is appearing for the DC?
14, 12.
Yes, so where is the,
This is 42 point.
what do you want to show me in page 48? What do you want to show me? This is all huh?
Fishery rules, Lordship.
rule 48.
Before that, Lordship, 12 is that government shall settle a 60% category fishery with special category. Government shall settle in 12. It is stated that government has to settle it.
Where, page?
Rule 12.
What do you mean by a 60% category fishery?
No, some fisheries are there where only the 100% cooperative society having 100% fishermen, they can only.
Okay, and some where there are 60% fishermen, they can be
No,
settled.
no, 100%, 60% fishery, no, 100% fishery, 40 is different, 60 is different. 60% fishery, only the cooperative society can be having 100% fishermen. Eligibility criteria is that.
No, I didn't get you. Provided that the government shall settle a 60% category fishery. What is a 60% category fishery?
Category, there is a separate fishery, to my understanding. 60% is a separate fishery where only the cooperative society can participate in the bidding process. Where 100% fishermen.
With 100%
With 100% fishery. But why does it say 60% fishery?
60%, they have, most probably they have 100 fisheries. They categorize 60% fisheries. Some
60%, 70%, 80%, like that?
Not like that. 60% category means 60% category. One fishery, this fishery is 60%. So here.
What is the
Names are there.
categorization based
Here,
on?
Lordship.
Come to page 12.
Names are there. That these fisheries are 60% category.
Except those referred in 8B.
No, what do you mean by a 60% fishery? I do not understand. Acha. At explanation 2, for the purpose of this rule, a 60% category fishery means 60% of registered fisheries available in a civil subdivision eligible for settlement in a particular year. So 60% of the fisheries of that area or in a sub, in a,
Yeah.
in a civil subdivision area has to be settled with cooperative societies, non-government organization and self-help groups. And the rest 40 will be the individuals and all those.
Cooperative societies can.
I think that is that's.
All can. This is for the purpose of.
Okay, so 48, no, you were saying?
Yeah, I'm saying,
Huh?
this 48 lots. DC has done rightly in what one part, Lordship, regarding cancellation of the lease, tender process. 48, last part, last paragraph. Lease value will be fixed for a period of 7 years at a time with 10% annual increase. 48, last part. Page 49.
Then where is the forfeiture provision?
Forfeiture is not, I don't think. we have
Forfeiture is
to-
not. Actually, there is forfeiture of performance security and all this stuff.
In my understanding, Lordship, DC cannot decide on the forfeiture part. That has to be decided by the fishery.
And out here, there is no fault of the petitioner. He has submitted his bid. Now the persons want that the bid should be made in a certain way.
I cannot do.
He doesn't want to do it. You cannot force someone to.
That part I am not agreeable with him, Lordship. That part DC has done rightly, Lordship, because 48 last part also.
48 last part.
Last part, last paragraph.
What does it say?
Lease value will be fixed for a period of 7 years at a time with 10% annual increase.
Okay.
He has not bid at a 10%.
10%.
So he has to give 10%.
In that case, my bid should have been cancelled.
Yes, so that's the reason all the bidders in the order, Lordship.
So if you, but why should his deposit be?
That part I leave, huh?
It's called deposit. Why should it
That
be
part-
forfeited?
That part DC, I am for the fishery development, Lordship.
No, but there are decisions of the court that your bid, your behavior should be that a contract should come into existence. And then you cannot take advantage of your own mistake. And because you are supposed to make a bid in terms of so and so. But then if it's wrong, it should have been disqualified straight away.
But that part has,
Is there anything in the NIT which says that it can be forfeited? Let us see the NIT.
in any way, DC cannot decide on that part, Lordship.
Whatever, let us see.
Page 24 is the NIT. But only the relevant portion has been annexed, translated. And others are in SMS from page 27 onwards.
I'm just going to the vernacular, Lordship.
Yes, please see in the vernacular. Is there any provision for cancellation, I mean forfeiture of the call deposit?
Four, Lordship.
Huh?
Four.
What does it say?
Complete question. Lordship, the translation part is there, page 24, Lordship.
I've got it.
Page 24.
This is nothing.
Lordship.
If the bidder fails to
Yes,
execute
fails to
Kabut
execute.
within a period of 1 month from the date of settlement.
That part.
So within the date of or fails to comply the
not-
terms and conditions as mentioned above.
Professor could have.
But that does not provide no ground. Just look at the other provision.
Lordship, that's very good.
You can say if I'm not eligible.
Huh?
I'm not eligible, they can say this can, they can just, not accept my bid. Not qualified.
Okay. Then okay, right. Heard Mr. V.D. Das, Learned Senior Counsel for the petitioner, assisted by Mr.
HR.
H.R. Das. Mr. P. Sharma appears for the Fishery Department and Mr. K. Gogoi appears for
12 Lordship.
respondents number 2 and 3. The last order, last order you just take from here What is this NIT? NIT dated?
NIT is dated, my lord. NIT is dated 1/9/23.
Are you sure?
Yes,
Let me see.
1/9/23. Page 20.
Come to page 41.
That is the second NIT.
Okay, that's the second NIT.
Second NIT where they were not allowing me to participate.
Okay, okay. That's
43, 43.
43.
First NIT is 1/9/23.
1/9/23 is at page 24.
You see, it says 29/9/23 out here. What is the NIT dated?
First NIT Lordship 1/9/23, page
Okay,
29.
okay.
Page 29.
So it's only with this case is only with regard to that provision, right?
Other relief he already got because pursuant to the
Okay.
interim order, he was allowed to participate in
Okay.
the second tender.
Then from here to here, I've put it, huh? The third paragraph. Then Mr. P. Sharma, the learned counsel for the fishery department submits that though the district commissioner has the power to cancel an NIT in term, this is that Mr. P. Sharma and Mr. K. Gogoi appearing for the respondent submit that though the deputy/district commissioner has the power to cancel an NIT in terms of Rule 48 of the Assam Fishery Rules, 1953. If there are no tenderers who have submitted their bids in terms of the in terms of the terms of the NIT, comma, the power to forfeit the NIT.
In terms,
Huh?
in terms of 48, last part,
What have I said? The power to forfeit the call deposit is not, is absent in the Assam Fishery Rules 1953. He submits that the power to submits that though the power to forfeit the call deposit is provided in the term and condition number 4 of the NIT, comma, the basis for forfeiture of the petitioner's call deposit is not, does not come within the provisions of Rule 4 of the term and condition number 4 of the NIT. There is nothing, are you sure, Mr. B D Das
Yes.
here?
They cannot forfeit.
Next. Yes, para. On considering the fact that the only question to be decided in the present case is with regard to the forfeiture of the call deposit of the petitioner, comma. This court finds that in terms of the NIT, comma, the call deposit can be forfeited only if the provisions of term and condition number 2 to 4. What? What have I said? only in terms of rule, only in terms of condition number 2 to 4 of the NIT. Dated 1/9/2023, which is as follows, huh? Page 24. Take that. Stop. Next. Stop. In view of the fact that the in view of the fact that in view of the submission made by the in view of the fact that in view of the fact that the Assam in view of the submission made by the council for the parties that the Assam Fishery Rules, 1953 does not provide for forfeiture of all deposit, and as the terms and condition number 2 to 4 of the NIT dated 1/9/23 has not been violated, this court is of the view that the forfeiture of the call deposit forfeiture of the call deposit on the ground that the petitioner had not made a correction of his tender documents, had made correction of his quotation as communicated to him by the respondents, is arbitrary. Consequently, the respondents are directed to reimburse, to release the call deposit of the petition immediately. The writ petition is accordingly disposed of.
Item 49, 50.
Item
51,
49/50.
50 and 51, they are similar, my lord, it is covered by similar order. So we may fix it next week, my lord.
Which are item?
49, 50 and 51.
But with regard to same.
It is covered by your lordship decision. Okay. Not this case, item number 49. Item number 49, 50 and 50.
This is
Not
with
this
regard to
order.
admitted amounts.
My lord, your lordship directed admitted amount, they have to, they have paid some amount, they have to pay more. So there is a judgment passed by your lordship also, that this will cover the case. So I think the order will be there. Order is not there today. So let it come up tomorrow, my lord, or Monday, my lord, next week.
No.
It is covered by your lordship. Earlier, when the committee
Show me
was.
the judgment, show me the order.
And 3837. 3837, lordship will can you see order dated page 81. Same tender process.
Yes, what is your submission, madam?
So for handloom textiles, we have a second instruction.
Okay. Miss
Which is in
Toshi
the-
Asenla. Miss Toshi Asenla. ASENLA, Asenla. Learned counsel appearing on behalf of Mr. Ardhat. For the state respondent, respondents 1, 2, and 4. Is granted 2 weeks time to obtain instructions. List the matter of the 2 weeks. In item 49 to 51. Oh.
49, 50, 51.
49, 50, 51.
Yes, similar. Same one, 49, 50, 50, similar.
But same order, same order in all the cases.
But 2 weeks, my lord,
Tomorrow it's not possible.
not tomorrow, next week. And then next week it can be, service is complete.
Nothing will happen, we fix it in March. Oblige. Sandeep, you. Yes. No time, unfortunately. Yes, Mr.
Item number 43, Lordship. In
Yes.
this case, in the year 2022 itself, Lordship, I deposited Salams, Lordship, for registering 2 lease deeds, Lordship. Till date, it has not been registered, Lordship. On last day, notice was issued, Lordship. Today, they were supposed to file.
Yes, what is to be done, madam?
Lordship, I have communicated with the department. I'm still awaiting my instructions, Your Lordship.
Okay, Miss
Ed Bordeloy,
Ann Bordoloi
respondent
is
number
granted
1.
a further 2 weeks time to obtain instructions in the matter. This is the matter after 2 weeks.
Lordship, considering the urgency of the matter, Lordship will dispose of this matter on the next date on the basis of available documents.
Let's see, let it come on the next day. Madam, you obtain instructions,
Yes,
it's taken a
yes,
long
Your
time. So you see, when you're on the other side, what happens?
How will I serve?
Yes, what about the petitioner person? What to do with your case? Yes, what to do in your case? Come here.
Yes, filed it, Lordship, application. Liberty to file the affidavit in opposition. Lord.
You want how much time?
You want some time to file? the
I already filed, but it doesn't been tagged with this case.
Okay.
So can you give another, say, 17 days time?
Okay, right. On the prayer of the petitioner person, this is the matter after 7 days.